Lordship, I may be pardon. Lordship, this is a Surface Act matter related to we are the auction purchaser. Sale certificate has been not issued to us, but in the meantime, one respondent has been died. Opposite part number 4. We file an IA for substitution. May be allowed any Thursday, Your Lordship.
That's CRL 736
Obliged.
23. CRL 736 23. So I for bail. Criminal appeal more than 13 years in custody.
Retired since 2014, not pension matter. And 19 is pleadings complete. That was listed but delisted. Thereafter, I have mentioned right.
Your Lordship, the petitioner here is an auction purchaser. The sale notice has been issued. Despite the same, possession has not been handed over to the petitioner.
Finally, pardon my lord, item number 4, single bench matter. Item number 4, single bench matter, my lord. I clear adjourn. Disconnection of power supply. Mr. Darachandra Makeup and counsel for the petitioner submits that this is a single bench matter. Let the registry examine the same and place for the appropriate bench with the approval of the Honorable Chief Justice. Yes.
Item 28, ma'am. Item 28, where the Mr. Abhay Kumar Behera, senior advocate, appeared in this case matter, so may be taken up Wednesday matter within 5 cases.
28.
Yes, ma'am. I have taken consent from Mr. Bhokta appearing on behalf of senior advocate. He is ill today also.
Achha. A mention is made on behalf of senior advocate Abhay Kumar Behera, the London counsel for the opposite party, to adjourn the matter today after tomorrow.
Yes. Within past 5 cases, so that it can.
The London counsel for the further submits that consent of the Mr. Bhokta and Central Government Council for the Union of India has been taken. In view of such submission, list this matter on 19th November 2020. Yes.
Pardon, mention also. Item number 11 also. I pray for Wednesday. Mr. Patnaik's first anniversary of his death, mother, it commenced to be tomorrow. Mr. Patnaik is has been on accommodation today because of the death anniversary of her mother. So I pray for Wednesday.
Mention is made on behalf of Mr. Umesh Chandra Patnaik.
11. Tell your name. Item number 11. Tell your name. Manas Ranjan Saujak.
Actually, they mentioned to the name. I will be mentioned to the
My power is there.
For adjournment, day after tonight. Put up this matter on 19th of
Item number 22 also same. Also.
Have you taken consent of the other side?
Item number 11, I have taken consent also.
It is further submitted that the consent of the land council of the opposite party has been taken. Yes, item number
22 also.
20?
22.
Same thing. Right after
In this case, the pleadings are not completed also. Not.
So like next thing.
Obliged also.
Thank you. Yeah.
Weekly Daily Fast Up, item number 1.
Results. In the case Mailer, the annexure 1 passed Mailer by the collector of Baleshwar. Pursuant to the application moved by the private bank Mailer, that is Dana Small Finance Bank Mailer, in the year 2023, my lord. Thereafter, under Annexure 6, my lord, it is found that in the year 24, my lord, they have initiated a criminal proceeding against the borrower, my lord.
You are the option purchase.
No, no, no.
Then-
I am neither the borrower, nor the option purchaser, nor the guarantor, my lord. The land like this, the plot number 261 and 262. I am my 261 recorded in my grandfather's name.
What you are doing since 23?
That was beyond my knowledge, my lord. When the bank officials came recently to because a building is situated over both the plots, my lord. In the joint, what the joint plot, my lord.
What you have when it came to your knowledge?
Recently, my lord, in 2025, my lord.
So what?
Then I have given a repetition, my lord, to the bank officials, my lord, under Annexure 5, my lord, at page 16.
Yes.
Then no action. Therefore, I move this.
See whether this plot belongs to you or not. Now these are disputed facts. So you have to file a suit and seek for injunction. How can a writ you can file and you want us
my humble contention, my lord, despite these several directions by the apex court and as well as the RBI guidelines, my lord, before sanctioning the loan, the bank must verify the records, my lord, the lands, my lord. Here, my lord, at my last issue,
in jurisdiction, we can't go into all these things.
I
file a suit,
I do not dispute.
More application
I do not dispute
1 and 2 and get it.
I do not dispute the bank officials' right, my bank's rights, my lord, against the borrower, my lord.
What right you have?
But
Unless you establish right, read
my humble submission before lordship, my lord, in this jurisdiction, my lord.
The order dated 22 order cases 49/2023 passed by the Learning Collector and District Magistrate under section 14 of the Surface Act. Directing for deputation of the executive magistrate to remain present during the process of physical possession, taking over of the physical possession of the secured properties, and to hand over the same to the authorized officer, Jono Small Finance Bank Limited, Bhadra, with a further direction to the Superintendent of Police, Baleswar, to provide police assistance for the said purpose. During course of argument, the Land Counsel for the petitioner submitted that the petitioner is neither a borrower nor a guarantor nor the auction purchaser, and he has raised certain disputed questions of fact and submitted that the order passed under Annexure 1 dated 14/9/2023 was not 2023 was not within his knowledge, and when it came to his knowledge, he submitted a representation on dated 1/9/2025 under Annexure 4
and 5.
4 and 5 before the Jana
Regional Manager, Jono Small Finance Bank.
Jana Small before the managers Jana Small Finance Limited sponsor.
Finance Bank.
Finance Bank Limited. Since the petition involved disputed questions of fact, and moreover the petitioner has got alternative remedy, we are not inclined to entertain this petition. It is clear that we have not expressed any opinion on the merits of the case. Accordingly, the petition is disposed of. Come to the petitioner, seek the appropriate remedy in accordance with law.
Annexure
One
5,889. Annexure 589. Annexure 402.
Annexure?
Annexure 5 dated 89. Annexure 4,019.
अच्छा 4 date होची 19, 5 को date होची 8, 9, 23. Yes, next.
Lakshmi, may I pray one person? Actually,
item
notice maybe I am not pressing the Lakshmi one prayer. May Lakshmi.
Yes.
Notice maybe should I am not pressing the imprimatur, my lord.
Item
Only as my instruction, my lord.
yes,
The parties are ready to settle, my lord.
all right.
You pass the same order.
Item number 2. May I please, Lord? The petition recognizing the order passed by the Lord
What is your
DRT.
prayer here?
I prayer before your lordship. Prayer number 3, page 16 below. To issue appropriate deeds to set aside order dated 36/2025, passed in disappeal number 383 of 2025, passed by the Lord DRT Kolkata, and upholding order dated 5/12/2024,
Who are you?
passed in.
Who are you?
Who are you?
Lord and the loan. Lord.
So you approach the DRT.
I have approached the DRT
You
in
lost-
essay.
You lost and then again you approach the DRT.
My lord.
Also DRT order went
DRT
against you.
Lord DRT passed the order on in annexure 1, Milord, page 19, Milord.
So
Your lordship may kindly
Come to page 21, para 7.
Milord.
Read it.
IA number 1210 of 2024 is filed for cross-examination of 6 witnesses by appellant perusal of 1 to 110 of 2024, which was filed before the DRT, would reveal that no ground has been taken by the appellant as to why the witness should be summoned and be permitted to cross-examine by the appellant. Simply a prayer is made and that the 6 persons be summoned for cross-examination. Non-counsel for the appellant would submit that this IA was moved on the basis of grounds taken in the securitization appeal. Your lordship, under section 17 of Suffice Act, and securitization application is still pending, wherein a reply is also filed by the respondents. DRT will deal with these issues at the time of disposal of the securitization application. Your lordship may kindly come to 22. Section 22.
And please,
Section 22 of the
please read and complete it so that we
Hon'Ble,
can be. Please read it. So I do not find.
I do not find any illegality, irregularity in dismissing the IA 1 to 10 of 2002.
This is your first grievance. Your IA is dismissed. First grievance.
Milord.
Next, read it. IA number 60. Next.
601 of 2023 is filed by the appellant for referring the matter for inquiry to the CBI, and further 7 queries are raised for referring the matter to the CBI. However, this IA was also appellant did not take any ground as to why the matter would be referred to CBI.
You will refer the matter to CBI.
Milord, because there is a rampant corruption was committed by the bank. Your lordship may kindly come to page 24, annexure 2. They have taken the money while they have sanctioned the loan in favor of the present petitioner.
DRT
That is 5 lakh.
DRT got the jurisdiction to refer a matter to the CBI.
Milord, have jurisdiction and cross-examination. I will draw your lordship's attention, kind
So then
attention.
you are not pressing for the second.
Both the petition I am pressing.
No, CBI thing, are you pressing?
Milord?
CBI thing, are you pressing?
Yes, Milord. As because there is a.
Let us see that which citation.
22.
You tell us that the DRT has power to refer a matter to the CBI for investigation. Sure.
Your lordship may kindly come to
So any
page.
prayer you can make.
Milord?
Any prayer you can make before any of them.
Milord, may kindly by.
You show us the citation. Show us the law.
No. That your lordship may kindly come.
Are you aware that how a CBI investigation is conducted?
Milord.
Only the constitutional court can give a direction.
Kindly bear a moment that by virtue of an order passed by the coordinate bench of this.
Please show us the law that the DRT.
I'm coming.
No, not coming. You show us the law. If you are ready, show us the law. We just want the
apology.
We want the citation.
I beg your lordship.
If you are not prepared, get prepared yourself. We want the law, the citation.
Giving the citation in 34, page 34, your lordship.
Yes. No citation, give it. We'll see that exactly. Give us it.
I have already submitted.
Which book? Which citation?
The petition for inquiry of
was the citation.
CBI was granted by this honorable court of a coordinate bench in CRLMP 25118 of 2022.
Which citation says that DRT has empowered to refer the matter to CBI for inquiry?
That part I am afraid your lordship.
First prayer goes. The first one is that 21210 of 2024. Come to that. May I draw your lordship's kind attention to section 22 is up to 1210 of 2024. Where is your petition?
That was dismissed because you have not raised any ground.
I am praying that my ground is in securitization appeal case. That is my prayer before
That is
the
pending. That's pending. That will be decided.
that has not been decided.
See, try to appreciate one thing. You move an essay. There you moved an application for cross-examining few witnesses without any ground. When the court is confronted with that situation, you say that 70 appeal is pending. All grounds have taken there. What is this?
No, my lord. As the ground has been taken in
this petition has been.
Your lordship may kindly come to the case.
Rather withdraw.
Section 22. Your lordship may kindly come to section 22. Section 22.
2020.
With the apology, your lordship may kindly come to section 22 of Recovery of Debt and Bankruptcy Act.
PR 80 Kolkata in Mishra appeal.
Your lordship may kindly adjourn to some other date. I will prepare and I will convince your lordship.
In so and so. The interim application has been IA number 1210/2024 has been filed by the petitioner in the pending essay number 131 of 2022 for summoning as many as 6 witnesses, and in the petition nothing has been stated by the petitioner for what purpose such prayer has been made to summon the witnesses. The learned DRT after going through the objection filed by the respondent bank, came to hold that the tribunal has to decide the issue regarding the irregularities committed by the bank while initiating the action under the Surface I Act. And the matter will be decided on the basis of the evidence adduced by both the parties and cross-examination of the ex-bank manager who has not initiated the action of the Surface I Act will not elicit any. Accordingly, the IA number 1210 of 2024 was dismissed, being devoid of merit. Similarly, the IA number 601 of 2023 was filed by the petitioner in the pending essay for a direction to hold an inquiry for referring the matter to the CBI. In the said interim application, also the respondent bank filed the objection, and the learned presiding officer has been pleased to hold that the petitioner has not brought out any irregularities committed by the respondent bank while taking action under the Surface I Act, and that the tribunal has to decide the issue regarding the irregularity committed by the bank while initiating action under the Surface I Act in this. And the matter is to be decided on the basis of the evidence filed by both the parties and with regard to the fraud committed by the branch manager. And the question of fraud cannot be decided in essay proceeding. The matter was challenged before the learned DRAT by the petitioner, and the learned DRAT has been pleased to hold so far as the IN number 1210 of 2024 is concerned. That no ground has been taken by the petitioner as to why the witnesses should be summoned and to permitted to cross-examine by the petitioner. Simply a prayer is made for summoning 6 persons. Though a contention is raised by the learned counsel for the petitioner that the IA was moved on the basis of the grounds taken in the securitization application under section 17 of the SURFACE Act, but since the said application is pending and the learned DRT will deal with the issues involved in the essay at the time of disposal of the securitization application, the learned DRT also didn't find any illegality or irregularity in dismissing the IN number 1210 of 2024. So far as the IN number 601 of 2023 filed by the petitioner for referring the matter for inquiry to the CBI, the learned DRT has been pleased to hold that the petitioner did not take any ground as to why the matter would be referred to the CBI. Rather, ground has been taken, rather contended that the grounds have already been taken in this securitization application, which is still pending. And therefore, the learned DRT held that the learned DRT rightly dismissed the interim application, holding that if any irregularity committed by the secured creditor in initiating the SURFACE measures, the same will be considered at the time of disposal of the essay. When we put a pertinent question to the learned counsel for the petitioner to show that whether the DRT has got any power to refer a matter for the CBI and whether the
that law has been decided in Madhya Chemical, Your Lordship. I have filed the judgment before Your Lordship for kind period.
Where that is
That law has been decided in Madhya Chemicals. Your Lordship may kindly come to my
where that which line? Which paragraph?
Your Lordship may kindly come to page 1021. On behalf of one respondent, may 49, paragraph 49. Sorry, my lord, I have filed only one
10.
You forgetting that you are addressing it in
Sorry, my lord.
Yes,
1021.
Yes.
Paragraph 49. On behalf of one respondent, see.
No, so that the line that the DRT can refer the matter to.
This is the principle of law. Why are you leveling hard on this? Only constitutional court can refer the matter to the CBI for it.
Case of the otherwise as provided under subsection 3 of section 69 of
Don't read that. We want that particular line. We are asking that where it has been held that the DRT has got power. There are several decisions of the Honorable Supreme Court, but you say that in this decision that has been held, show us that particular line.
No, in this case,
please show us that line. Is there anything in this line? Then why you interfere in the midst of the dictature? That in that decision it has been held.
For that, as the matter has been already.
The learned counsel for the petitioner so submitted that in the case of Madhya Chemicals Limited versus Union of India, the same has been that it has been held that the Debts Recovery Tribunal is empowered to refer the matter to CBI. But when we went through the decision, we found nothing in that respect has been stated by in this said case. In view of the foregoing discussions, we find no infirmity or illegality in the order of the current DRT. Accordingly, the petition being devoid of merit stands dismissed. Yes, next.
I beg pardon. Only one line, madam. This is matter related to 22. And this honorable court in some other matter when he has come, it has been targeted. And both the way filed by him is related to filed by me. It is related to 2019. My lord, I have not carrying. I am sorry for it. Recent judgment speaks that DRT should dispose of the matter within the stipulated time fixed by the statute. So kindly end here. As per the direction, we have already filed the written note of argument.
Our petition has to be decided by the DRT.
Since
Unless the petition should be
note has
decided,
been filed.
how
Let it be fixed date
how
that
the
it should be
DRT
disposed of.
had the entire essay
essay
and
of
decided-
year 2022, and it is stated that the pleadings are complete.
And the written note of argument has been filed.
Argument has
As per the direction of the honorable DRT.
my IA is pending, my lord. My IA is pending.
This claim shall be disposed of within the time limit as prescribed by the Honorable Supreme Court in the case of give that issue.
I will give.
Yes, next.
May I permitted to only place one statute, your lordship.
Yes, next.
My name
Your lordship may
may be the
kindly permit me.
The dissent. Yes.
The decision must be
dissent of the
Yeah.
Item 3.
The Land Council for the petition seeks permission to withdraw the petition to oppose the DRT accordingly disposed of as we go. Well, liberty may be granted, so liberty is granted. Disposed of the case. Liberty should be
Item 5.
May I read your lordship? The lordship in application agency action of the chief manager come authorized officer Punjab National Bank in taking possession of the mortgage property on 29/8/2025 under section 13(4) of the Surface Act 2002 without settling the loan amount.
without.
Well, sir, we have given a representation, my lord, on 8/9/2025.
You have
one-time settlement.
You have availed the loan.
You are the loaning.
My lord.
So 13 for notice issued. You have got alternative remedy.
30 days time was given to us for remediation of the property, but 4 days later we have given a representation. We want to settle the matter on one-time settlement.
Remedy is somewhere else.
Somewhere else.
Your Lordship, last Friday it was listed. Similar matter, Your Lordship has passed order.
The petition has been filed by the petitioner who was the loanee challenging the notice dated T9/2025 issued by the Punjab National Bank
Punjab National.
under section 13(4) of the Surface Act. In view of the distance so and so, an alternative remedy is available. So, sure, ये लॉरेंट काउंसिल फॉर दी अपना ना दियो नहीं madam raised objections regarding the maintainability of the writ petition on the ground that alternative remedy is available to the petitioner. Yes, next.
Item 6.
Please, my lord. My lord, this is a matter where, my lord, I had taken a home loan. Thereafter, my lord, my brother and take loan on my property, which was an extended loan, my lord. And this was given as
Just to come to that order.
my lord, order is at page
12/11/2025.
30/10/2025.
Please come to the our previous order.
Previous order.
Yes. High Court of Orissa.
Are you having that order?
Yes, ma'am. Yes.
Please. Mr. Mishra, you are for
Yes.
land.
I'm for the option purchase.
Both Mishra.
Both the matters, my lord, for the bank.
And council files Vinama for
State Bank of
India. Which is taken on record.
My lord wants to know that order 29196.
12/11/2025 आम ऑर्डर टा टिके प्लेस करंतु नाही ऑर्डर जदी कहलेनी
नहीं नहीं सॉरी माय लॉर्ड
आ सेठी बाहर कर दे
नहीं नहीं सॉरी माय लॉर्ड 12-11 ऑर्डर टा इज नॉट विथ
Just see from
Just
there.
see that. ଆପଣମାନଙ୍କ କଣ୍ଟେଣ୍ଟ ତମ ସିଏ କହିକି ଗୋଟେ ଅର୍ଡର ଟା ପାସ୍ ହଉଛି ଗୋଟେ ଡେଟ୍ କୁ ଆଡଜନ ହଉଛି
Sorry, sorry.
ଅର୍ଡର ଟା ସେଇ ଦିନ
Sorry, sorry,
ତାକୁ
sorry.
ପଢିବାର ଦରକାର
Sorry.
ପ୍ଲିଜ read it out.
Yes, the matter is taken. The writ petition has been filed by the petitioner Jajati Kesar Janu challenging the order dated 30/10/2025 passed by Lanet DRT Cuttack in SA number 160 of 2025 on the Annexure 1, in which the Lanet DRT has dismissed the interim application filed by petitioner by IA number 1349 of 2025, wherein a prayer was made for a direction to the bank not to take any further action in respect of scheduled property pursuant to the e-auction sale notice. Mr. Mishra, learned counsel appearing for the bank, submits that no interim order was passed in the interim application, and in meantime the bank has completed the auction sale and sale certificate has been issued in favor of one Mandakini Raut, the auction purchaser, who had approached this court in WPC number 29196 of 2025, in which the petitioner Jajati Kesari Jana has filed an interim application by IA number 20021 of 2025 for intervention. In view of such submission, the list this matter on 17/11/2025 along with WPC 29196 of 2025. Let Mr. Learned Counsel for the petitioner serve a copy of writ petition on Mr. Mishra, Learned Counsel for the bank in course of the day, and since Mandakini Raut, who is a petitioner in writ number 29196 of 2025, has also added as an opposite party number 5 to this writ petition, Mr. A.K. Vishwala, Learned Counsel has instruction to appear for the said opposite party. Let a copy of the writ petition be served on him in the meantime.
This writ petition has become infructuous.
No, my lord.
You have to contest that writ petition.
No, my lord. It has not become infructuous, my lord.
This is the prayer, my lord.
1 minute. My lord has put me a question. My lord, why it has not become infructuous? First and foremost, my lord, no notice was ever served on.
That point can be raised there.
It was raised. It was raised, my lord.
Then
now what miscarriage of justice has taken
no,
place?
it has raised and it has been dismissed.
No, my lord, dismissed at what time, my lord? And how much time was taken, my lord?
No,
my lord, kindly.
Can you not approach the DRT?
My lord, 1 minute. My lord, first, my lord, no notice was ever served. My lord, just let me place my facts, my lord. No notice was whatsoever was served to me. Then, my lord, Rule 85 was never complied, my lord. So no notice was served. Secondly, my lord, the valuation report, which is the foundation for any option to happen, my lord. No valuation report was prepared by the bank, my lord. Rule 85 mandates that the valuation report has to be published. Second, my lord, single bidder, my lord. I'm not on that single bidder also, my lord.
All these things you have to file.
We have filed. Now, my lord, coming to the
file DRT and tell all this.
Yes, my lord. All those IA, in that IA, we have mentioned everything. And secondly, most important thing that we are ready to pay off the entire amount. And this property is, my lord, a valuation of 4 crores, my lord. Valuation report, my lord, I will show it is 4 crores. My lord may see at the page, my lord, valuation report.
Primarily, you are coming in this writ petition against 13-4.
1 minute, please.
At that stage, he has come.
Interim order stage, my lord, I have
interim
come.
application. You argue on this thing.
No, my lord, I have come before this interim application. Why? Let me first clarify. My lord, let me clarify one thing. My lord, that interim application, my lord, was filed by me after the auction, definitely, because I never knew that auction was happening. After the auction, my lord, I filed that application, my lord, and IA was not taken up. IA, for first time, I came to, then they filed an objection. In the objection, my lord, I came to know that sale certificate has been issued. That time, my lord, sale certificate was not issued. After the issuance of sale certificate, by that time, my hearing was there. I was conducting the hearing, but no stay was granted to me. Neither it was taken off of me.
What is the due amount?
My lord, due amount is not on me, my lord. That's what I am saying. I am a guarantor in that property. Now the guarantor's property, which is another submission, my lord. Guarantor's property has been put to auction.
Once you know.
Yes, my lord.
That sale certificate has been.
Sale certificate I came to know after the IA was filed and after.
Have you made amendment in that?
My lord, after 4 days it was dismissed, my lord. My lord, the moment the objection was filed,
it is dismissed.
My lord.
What was your essay has been dismissed?
No, IA was dismissed. I was not granted any stay.
IA was not filed for amendment.
No, there was no scope for me to file an amendment, my lord. Why, my lord? Because
once you know that sale certificate.
No, I came to know when objection was filed, my lord.
So, like now you know or not?
Now I know now the sale certificate is issued. Now, my lord, question is this. Question is this, my lord. Can a guarantor's property be put to an auction? Sorry.
Later, it is offering 1 crore. 8 lakhs something. পয়সা তো প্রয়োজন।
My lord, auction amount.
My lord, auction amount was 1 crore 85 lakhs. That was the reserve price.
My lord,
person was there.
Kindly,
certificate
my lord, kindly appreciate valuation report. Valuation report.
If you simultaneously tell, we cannot do it.
But two things I want to point out.
Yes.
Kindly see the prayer. He has twofold prayers. One is quash the impugned order 30th/10/2025 passed by DRP. That is an appealable order. Stay has been rejected. Secondly, quash the e-auction notice. Now, can we go over multiple proceedings? Now, the e-auction notice is subject matter of challenge before DRP, which is pending.
My lord, now.
So that prayer goes this way.
My lord, kindly
Mr.
appreciate.
Patnaik, we expect that some decency. He's arguing.
Sorry.
Those two prayers. First prayer is to quash the interim order. That appealable. Second is quash the e-auction. For that essay is pending. Third thing, my lord, what he's saying, if your lordship will see page 36, the last paragraph. I want to read that out. Kindly see, my lord. What he is saying, what is not gone from the records that he didn't have time. When I filed the objection,
read that.
My lord, from the perusal of the record, it is seen that the property has already been sold. My lord, page 36, last paragraph, the impugned order. From the perusal of the record, it is seen that the property has already been sold and sale certificate has also been issued in favor of the auction purchaser. Applicant has neither imputed the auction purchaser till date, though the applicant has already received the details of the auction purchaser, nor amended the essay till date. It is also a fact in the meantime, the respondent bank has issued sale certificate. Though the applicant has prayed for stay of taking over physical possession, but the applicant has not pleaded anything about the physical possession of the scheduled property in his petition, nor amended the essay accordingly. Bring those facts and record. Hence, no interim order can be passed.
So that is the fundamental
mistake. Yes,
my lord, kindly appreciate. My lord, kindly
submission. I'll take 5 more minutes.
And the auction purchaser came to this court. We issued notice directed next person.
Yes, my lord.
From the order.
From the order of the Honorable High Court dated 17/10/2025, passed in WPC number 29196 of 25, it is seen that the Honorable High Court has asked the state to apprise the court as to why possession of the purchased property has not yet been handed over.
My lord.
Yes.
My lord.
Let me complete it. My lord, first the prayers. One is interim order. I've got the judgment. Your lord knows I did not show the judgment. It's an interim order. He has to go deposit 25%. Then his appeal will be admitted. He cannot short circuit that by coming here. Yes. The second pair, auction notice passing, essay is pending. So when essay is pending, would your lordship entertain that?
Yes.
Third thing, my lord, the essay as it stands today is infructuous. Yes. Because neither the section 14 prayer was there in the stay petition, nor that was there in the essay.
Will be taken care of by
that the DRT will take care of, my lord. That remedy is still open to him.
Anything?
Yes, my lord, just my lord, one. My lord, kindly see the valuation report for a moment.
We are not entering into that.
No, because my lord, the valuation report is 4 crores, my lord.
We raised that.
No, but my lord, if I am not protected, and my lord, why I cannot go to, because this writ petition is pending, my lord.
We are disposing of the writ petition.
My lord, kindly appreciate one thing, my lord.
Petition.
My lord,
Just maintainability,
my lord, one thing, my lord. Can I submit my?
Dated one, so annexure 1 passed by the London DRC in essay number 4. It appears that in the input order, the while adjudicating the interim application, which was filed for a direction to the defendant number 1 K bank.
Yes.
The defendant the bank not to take any further action in respect of the civil property pursuant to the e-auction sale notice. The London Tribunal has been pleased to hold as follows: quote from the perusal of the record till devoid of any merit. There is no dispute that against the impugned order dated 30/11/2025, 30/10/2025, passed by the London DRT in essay number so and so. The appeal is maintainable under section
18 of the Surface Act, my lord.
Under section 18 of the Surface Act to the DRAT.
My lord, one judgment also have given just.
Yes.
The in the case of Varim Ma Dugu Reddy versus which paragraph, Mr. Mishra?
My lord, paragraph 34 to 36.
36.
In
page 181 internal page, my lord.
In paragraph number
34 maybe.
It has been held as follows. Quote from paragraph number
34 to 36, my lord.
34, no,
To 36.
35.
35 or 36, my lord.
35.
They have the Honorable High Court had entertained, my lord, so that was deprecated by the Apex Court.
So far as the second prayer made in the this writ petition is concerned, it was the e-auction sale notice dated 9/6/2025. The same prayer has been made by the petitioner in the essay number 160 of 2025, which is sub judice. Therefore, we are not inclined to entertain this writ petition, which stands to exist. So far as the second one is concerned,
Lord, it has worked itself.
yes. What is your prayer, madam? Who has filed this?
The auction purchaser, my lord, it was a direction to the bank why physical possession was not handed over. Your lordship pursuant to the direction it has been done.
Yes, what is your response?
You know, my response is this, my lord, no notice was ever submitted to me. No notice has ever come to me, my lord. So I never got a chance to give my bid, my lord. My lord may see that if I am not been given, this is a guarantor's property, my lord.
Second, you want to contest?
My lord, let me be given a chance, my lord, at least to deposit that amount. My lord may see the order, my lord.
Now you have been included in the second petition.
Yes, my lord. I am ready and willing to give the entire reserve price, man. 185, I am ready and willing to deposit, my lord. At least if I deposit that amount, let it be open, my lord.
I have only one small prayer. First, in the DRT, they have not impeded the auction purchase.
Hey, my lord, that because I never knew that, man. I will impede it.
See, in the second case, he has been impleaded.
In the case, he is there before your lordship.
Then he has the right to sue.
Yes,
My lord, because it is sub judice there, anything on merits here, my lord, that will materially affect.
No,
definitely.
The second one we are talking
Yes,
not in the
about
first.
the second.
First one is disposal.
Second one is linked, my lord, because second one is the auction purchaser. So if the auction purchaser, he did not make a party.
My lord may see the
What
page.
is that IA for which has been filed?
He has filed to be here. He has filed IA number as per his year 20021 of 25.
So this was filed by whom?
This was
Filed this Jajati
Yes, my lord. Filed by me.
for intervention.
Yes, my lord.
We are allowing this intervention application. He has a right to intervene. And then we'll decide it.
No, my lord, what has happened, my lord, in this entire, I'm
You
ready.
don't want to intervene.
My lord, I am intervening. My lord, only thing is that if now,
just a minute, IA number 20021 of 2025, there is an application filed by one Jajati Kesari Jena for intervention. The
I am taking my position.
He is the guarantor.
He is the guarantor.
There is no dispute that the petitioner or the intervener, proposed intervener, is the guarantor of the property in question.
mortgager cum guarantor.
To the loan, which was also the subject matter of the case. Therefore, we feel that is a necessary party, and accordingly, the interim application is allowed. And you have received the copy of the writ petition.
No, man.
Let a copy of the writ petition be served on Mr. Patnaik by during course of the day by the land council for the petitioner. Matter be placed on such and such day. Objection, a counter affidavit if any to the writ petition.
I am ready and willing to pay. Nothing else. When taking on possession, my lord, I am ready to pay the entire amount. And the valuation, my lord, is more than that.
I am taking my position.
My lord, kindly one thing more.
Just a minute.
We have allowed your application.
Yeah, I think one more submission.
The current council for the state has produced a letter dated 12/11/2025 from the IAC Dharmasala Police Station, Jashpur, which shows that the State Bank of India has already purchased a house and market complex of village Gangadharpur, Nakpoili on 1/11/2025. The written instruction is taken on record. Matter be placed on such and such day. Counter affidavit is filed. Yes.
My lord, one thing can my lord me. My lord, if I approach now DRAT, my lord, this repetition will stand in the way.
Yes.
They may not.
Next. Item number 7.
Item 7.
Not any date in December I am impressed.
We'll see that.
As my lord.
Now you are in position. What is there, sir? You are not passing any interim order.
My lord.
And at least they may not create any third
Where
party.
is your application? Your application is only for improvement we have allowed. You have not asked it.
Yeah, because my lord, I had filed my writ application, my lord. Now the writ application is disposed of, my lord.
Next, item number 7.
Application.
Item number 7. Mr. Mukherjee.
I obtained a loan of rupees 40 lakhs from the opposite party by opening a CC account. The account was subsequently declared as NPA as I have not paid the dues in regularly.
So demand notice you are challenging.
Yes, notice I am challenging the demand notice that is annexure 1.
Challenging the demand notice.
My lord.
Demand notice is you 13(2). You have got a right to file your response representation under 13(3)(a), which is to be adjudicated in a particular time limit. Have you made any such?
Before that, they have given a possession notice. That is annexure 3, page 16.
This notice, if you see, this is a demand notice under 13(2) in the top of the. After this notice, have you you come to even the last portion of that?
On the surface act, they have sent the demand notice, but before that on page 16, your lordship kindly see.
You see, hence in exercise of the power under the surface I act and without prejudice to the right of the bank and to the pending funds, the bank hereby calls upon you to repay
in full the amount of so and so within 60 days from the date of receipt of the notice, failing which, in addition to and without prejudice to the other rights available to the bank shall be entitled to exercise and all of the powers under section 13. So they have given you an opportunity, and the statute says that once you get such a notice from the bank, what you are required to do. It says that if on receipt of the notice under 13.2, the borrower makes any representation or raises any objection, the secured creditor shall consider such representation or objection, and if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of the receipt of such representation or objection the reasons for non-acceptance of the representation or objection to the borrower.
My lord. After
this demand notice, what you have done?
I have made a representation. My lord.
It seems that thereafter the starting for notice has been issued.
After getting that demand notice, I made some payment that is 2 lakhs and also made a representation. I have made another 2 lakhs rupees. Before that, I have paid 5 lakh rupees. After getting that demand notice, I have paid 2 lakhs rupees and also made a representation.
Once this 13.4 stage comes, means you are to go to the DR.
That's the problem. 13.2 notice was given. You gave representation
of
whatever.
30 odd lakhs and you gave just 5 lakhs.
And
And
thereafter 13.4.
then 13.4 notice and you have got alternative remedy.
Annexure 3. So you are Annexure 3. You have been giving representation, but Annexure 3 just see. This is 13.4 notice. Then remedy against that is DRT.
Well, after getting that notice, I made 2 representation. I have paid some amount, my lord. And now I am ready and willing to pay the rest of the amount.
The scheme of law is after 13.2 you have to give representation, not after 13.4.
Right.
13.4 you have to go to court. What you did is even after 13.4 you keep on giving representation. It's neither here nor there. That's not the law.
The petition has been filed.
But what my submission is that I am ready and willing to pay another deal.
Make such a prayer before the DRT challenging the demand notice dated 10/6/2025 of the chief manager and authorized officer of Bank of Maharashtra, Bhubaneswar zone. In the demand notice, it has been specifically indicated to the petitioner that he has to repay in full an amount of rupees 37 lakh 19,244 and rupees and 86 paisa plus future interest as per applicable rate with effect from 10/6/2025 and other charges within 60 days from the date of receipt of the notice, failing which, in addition to and without prejudice to the other rights available to the bank shall be entitled to exercise and oblique all of the powers under subsection 4 of section 13 of the Surface Act in respect of the securities public properties enforceable under the Act. I
made representation within stipulated period of time
seems
after
that
getting that demand notice.
Petitioner deposited a sum of rupees 5 lakhs. 5 lakhs.
And another 2 lakhs I have paid.
And also another 2 lakhs as stated by, it seems now that the land council for the petitioner submits that after receipt of such demand notice, the petitioner has paid a sum of rupees 5 lakhs at one instance and 2 lakhs at the other instance a year. And to that effect, he has filed the documentary proof which is taken on record. The land council submits that in spite of such payment being made, the possession notice has been issued on 3/9/2025 by the bank. And thereafter, the petitioner has also made some representation, but no fruitful purpose has been served. It appears that though prayer has been made to set aside the demand notice dated 10/6/2025, but since the subsequent event has taken place and the bank has already issued the possession notice under section 13(4) of the Surface Act, and in view of the settled position of law and so, since alternative remedy is available to the petitioner, we are not inclined to entertain this application and give liberty to the petitioner to approach the appropriate forum. It is made clear that we have not expressed any opinion on the merits of the. Yes, next.
Item 8.
Opposite parties be directed not to take any coercive action.
Not maintainable means no direction. Yes, next.
Item 8.
Number 8.
Against the order of London Central Administrative Tribunal, this writ petition is filed.
Yeah.
London Central Administrative Tribunal rejected my original application only on the ground of limitation without looking into the with misconception and without looking into the section 21 of the Administrative Tribunal.
You have filed for amendment.
But this at the your lordship may kindly see the order dated.
Have you given a copy to the
yes,
Yes, sir. I have also filed objection to that.
To the IA. So anything further you want to say? This IA interim application, the he wants to take some grounds.
But what my objection, I have only stated that has not been the ground which has been mentioned in this.
No.
The grounds which has been taken to amend in the writ application, that is not there before the tribunal. That is the objection.
No, it is some legal things here.
This counter and regounder is to the IA, not to the main petition.
On to IA.
Only IA.
Because court, your lordship may kindly see order dated 4/1/2024.
These are new grounds you are taking?
New ground. Your lordship may kindly see paragraph 6 of the order dated 4/1/2024.
No. We are considering now this has come for orders. We are not entering into the merits.
That
the interim application has been filed for amendment of the writ petition, and objection to that interim application has been filed. What they say that you are now trying to incorporate after paragraph number 10, 5 more paragraphs.
Yes, sir.
But in those 5 paragraphs, you are taking such grounds for the first time here, which has not been taken before the London Central Administrative Tribunal.
Your lordship may kindly see the order dated 4/1/2024. Paragraph 6. When this matter was taken up for admission, this matter was argued, and the Honorable Court has granted me the liberty to file some documents to prove that the cause of action was arose in within the limitation period. Your lordship may kindly see paragraph 6. At this point of time, my lord,
let us see para 4 also. Read. Mr. Oja called for the petitioner contended.
The order ta portile podandu 5/4/2024.
Such and such the had Sri S.K. Oja Lana Council for the petitioners and Sri B.K. Padhi Lana Central Government Council appearing for the Union of India. The petitioners have filed this writ petition seeking to quash the order dated 16/11/2023 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 735 of 2022, rejecting the claim of the petitioners on the ground of limitation. Sri S.K. Oja and Council for the petitioners contended that Tribunal has committed gross error refusing to grant relief to the petitioners on the ground of limitation. Learned counsel for the petitioners relied on the decision of the Honorable of the Apex Court in the case of Matthew David versus State of Kerala and others reported in such and such, disposed upon 13/3/2018, and this court in the case of Sri Devi Prasad Panda, Union of India and others reported in such and such. According to him, the Apex Court as well as this court has already opined that once the benefit is extended to the similarly situated employee, the same should have been extended to the petitioners therein. Mr. B.K. Padhi, Central Government Council, contended that petitioners are the fence sitters and as such are not entitled to get the relief claimed by them. The tribunal is well justified by passing the order impugned. It is further contended that a group of persons were extended with the certain benefits by the order dated 5/9/2022 on consideration of representation filed by them pursuant to the direction issued by the tribunal. After such benefits were extended to them, the petitioners wake up from deep slumber and filed their representation only on 14/9/2022. Therefore, the tribunal held them to be fence sitter and dismissed their claim on the ground of delay. According to him, the persons who got the benefit, they had approached the authorities well within the reasonable time, whereas petitioners raised their claim only after the order dated 5/9/2022 was passed. Hence, the petitioners are not entitled to get the relief as prayed for by them. He further contended that the judgments which have been relied on by the learned counsel for the petitioners are actually distinguishable.
Actually distinguishable. Actually.
Petitioners are not entitled to get the relief. The further contended that judgment which have relied on by the learned counsel for the petitioners are factually distinguishable as because in the case of Matthew David, the petitioner therein was functioning as pharmacist on being periodically engaged on daily wage basis. Therefore, the Apex Court held that petitioner therein is entitled to for appointment to the post of pharmacist homeopathy, since the said benefit was extended to the similarly situated person. In the case of Sri Devi Prasad Panda, in which one of us, Dr. Justice B.R. Sadangi, was the member, this court took into consideration non-denial of compassionate appointment to PA/PS cadre on the ground of non-availability of post, despite the fact that similarly placed persons have been given appointment. Therefore, this court observed that opposite parties made clear discrimination to the petitioner and accordingly directed to appoint the petitioner in the PA/PS cadre. The fact of the said case is completely distinguishable from the present case. At this point of time, Sri S.K. Ojha and counsel for the petitioners prayed for some time to satisfy this court that the petitioners cannot be treated as fence sitter. On the request of learned counsel for the petitioner, solve this matter such and such. This stand I have taken, I will satisfy this honorable court. Instead of filing any additional affidavit or further affidavit, I brought some documents by way of amendment.
So that you are not differentiated.
Yes, only that much. No further ground, no new ground I am advancing. Only some documents that cause of action arose on July 2022, and they have taken the decision on my representation on 14/10/2022. I filed the application only 19/12/2022, well within the period of 1 year as per section 21. Section, if you for a moment, my lord, your lordship may kindly see section 21.
Yes. Yes.
Section 21.
Yes.
Lord. Limitation. A tribunal shall not admit an application. Section 21. This is the limitation part of administrative tribunal. A tribunal shall not admit an application. A. In case where final order such as in mentioned in clause A of subsection 2 of the section 20 has been made in connection with the grievance unless the application is made within 1 year from the date on which such final order has been made. 2. In case where an appeal or representation such as is mentioned in clause B of the subsection 2 of the section 20 has been made, and a period of 6 months had expired thereafter without such final order having been made within 1 year from the date of expiry of the said period of 6 months, notwithstanding anything, but then how that will be condoned. I am coming within kind of one
No,
second.
you are correct. From the 5/9/2022 is the order passed in so far as the other people are concerned. From that day, 1 year, within 1 year you filed. Before that, what you have done? That's the question.
Before that, my representative for the first time benefit was given to the similarly situated person in
from that day you within 1 year you filed. But before that, why we are not approach the court? That's the question.
My humble submission. Inter-commissioner transfer so far as income tax employees are concerned, as per their transfer policy, no benefit of past service will be given to them.
Yes, you have to surrender that.
Will be given to them. Then for the first time, the Honorable Apex Court in the Rajasthan case has held, since the earlier service is also the regular service, that will be taken into consideration. That was submitted in Prabha Devi case in 2018. Thereafter, no seniority list or promotion was made here in Commissionerate of Bhubaneswar. For the
that position is also now changed.
Yes, my lord.
That position changed.
Then, my lord, in 2022 July, they have given the benefit of promotion. The promotional DPC was held. They consider some persons, ignore we. Then we made the representation to the authority that since you are considering the similarly situated person and the Honorable Apex Court has already laid down the law, therefore you should consider us. They rejected my application, indicating that since that order is in personam, not in rem, therefore since you have not approved to the court, therefore you will not get it. That is the specific order. Apart from that, my lord, they have rejected so many applications. Two persons, my lord, I have filed the application and another person also filed the application before the Law and Tribunal at the same time. My application was rejected on the ground of limitation that you have not, you are a fence sitter. So far as the other application is concerned, your lordship may kindly see that was allowed on the basis of that Prabhadevi case also. I have also
after you are
yes, my lord, your lordship may kindly take note this decision, my lord. Same, my lord. Say 14/10/2022 order. I have challenged. He has challenged. He has also challenged.
Benefit given to them.
Yes. Kindly see, my lord. Same order was challenged, 14/10/2022. I have challenged. I was rejected on the ground that you have not approached, and he has also challenged.
When you filed the OA?
I filed OA 19/12/2022.
And this man filed the OA on
B Mas Purburu. He has filed the OA 16. He paragraph 2 रे लिखा है. He has filed the OA. Blood. Your lordship may kindly turn to paragraph 7. Paragraph 7. Hence, being agreed by the aforesaid order dated 14/10/2022, which I have impugned, the applicant has filed OA on 31/10/2022.
This judgment?
Yes. Para 7, Mila.
Then forget about the parity with that judgment. Follow the parity with this judgment. Forget of that. Forget about everything. If you give it to this man, give simple. Don't go into all this.
We are allowing the interim, the amendment, IN number so and so. There's an application for. No, it does. I see other things. So let it. Number so and so. There's an application for amendment of the writ petition. the grounds have been taken in the interim application to show that the cause of action for initiating the way arose for the first time on 19th July 2022, when promotions of the juniors were given effect retrospectively. And secondly, when their representation filed in various dates in the month of July 2022 against such orders was not considered. Thirdly, when the seniority list was published on 5th September 2022, lowering down the position of the petitioner in comparison to with the juniors. And fourthly, when the petitioner filed their representation during the month of September 2022, and lastly, when the notification dated 14th October 2022 was notified rejecting the representation of the petitioner. Stop. It is submitted by the Land Council for the petitioner Mr. Oja, pointing out section 21 of the Administrative Tribunal Act, that since the petitioner approached the Land Tribunal within a period of 1 year from the date of the cause of action arose in the matter, dismissing the original application on the ground that the petitioners are the fence sitter cannot be treated as proper reason. Mr. Ujna also brought to the notice of this court that one Mr. Ajay Kumar Biswal, who also approached the Land and Tribunal against the order dated 14/10/2022 in way number 260/0058 of 2022 was granted relief, whereas the prayer of the petitioner was torn down. The Land Council for the Union of India has filed the counter affidavit to the interim application for amendment of the writ petition. After going through the amendments taken in the interim application and the counter affidavit and hearing the Land Council for the respective parties, we are inclined to accept the prayer made in the interim application and permit the petitioners to amend the writ petition as per the schedule. Indicated 7 days. The consolidated writ petition we filed within 7 days, serving a copy on the Land Council for the Union of India, and the matter be listed thereafter for admission. Huh? Acha. The Land Council for the Central Union of India shall obtain instruction as to whether any challenge has been made in the meantime to the order dated 24/9/2025 passed by the Central Administrative Tribunal in the case of Ajay Kumar Biswa in OA number 260/00584 of 2022.
See, if it attains, if it is attained finality, you have to give.
Fresh admission you're not kind of fixed it.
ଆପଣ ଦେଲେ fresh admission ଆସିବ ଏହା କୁହାଯାଇଛି 7 ଦିନ ଭିତରେ ଫାଇଲ କରି
appearance memo.
ଆଚ୍ଛା the appearance memo ଟା we're just coming within 2 minutes.
Item 9.
And in response to the IA, my friend has filed the counter affidavit, and on perusal of the counter affidavit, I think that something has been spelled out in the counter affidavit which requires to file a rejoinder to them. So I am suggesting one thing: let the matter be taken up next week. In course of this week, I will a rejoinder will be filed. That will be better for appreciation and administration.
What is this matter, Mr. Mahapatra, this judgment in the special leave petition 22/9/2025?
Just I am explaining my lord. Eviction notice was given. Eviction notice was given to the petitioner after the final adjudication of the matter, and that was
Eviction notice means from his property.
Enforcement director.
Acha, okay.
That was challenged before this honorable court. My lord disposed of that matter with a direction to prefer appeal because appeal was not preferred.
Okay.
And that order was challenged before the honorable apex court. Two submissions were made. So far, the first part of the honorable apex court's direction is concerned, they similarly observed that what this honorable court observed to prefer giving a liberty to the petitioner to prefer appeal as this is statutory appeal that was not filed. In pursuit of that, appeal was filed. So far, the other aspect is concerned, a motion was made before the honorable apex court that in the mean period, in pursuant to that notice, she has already been evicted from residential house. So the honorable apex court give a liberty on the second part of the order, alternative liberty that to approach this honorable court to file a interim application in the disposal of writ application to consider whether the property
to seek the restitution of possession having regard to the result of the appeal.
That was the order. So that is how you have filed.
A petition was filed in pursuant to which my friend has filed the counter. I want that.
What is the stage of appeal? What is the stage of the appeal?
Appeal has been admitted.
No step has been taken.
You have not filed appeal.
Except filing, no step has been taken. Pursuant, you will also kindly see the order of the apex. Pursuant to apex court order, no application has been filed.
Yes,
my lord, kindly see the order.
This order of the honorable
apex court, my lord.
Yes.
22/9/2025.
Yes.
First page, it is observed that if such an application is made by the petitioner before the appellate authority, the same shall be considered as expeditiously as possible on its own merits and in accordance. No application has been filed, my lord. Except filing appeal, no step has been taken for admission of the appeal. No application has been filed pursuant to direction of the apex court. Straight away they have come before this honorable.
No, but this is last observation. Alternatively, alternatively, the petitioner is also at
liberty to file an application
dispose of matter before the High Court
seek restitution having regard to the result of the appeal, my lord.
Yes.
No step has been taken for appeal, my lord.
Appeal he has filed.
Appeal already filed, my lord. No step.
Now the question today is during the pendency of the appeal, what will happen?
Yes, and so apex also said, my lord, he will move an application there, and the appellate tribunal will consider. No application has been filed
for the restoration of the possession. That no sir. Liberty was taken to file appeal, and
that is for merit disposal, Mr.
Yes, my lord.
But that application is for merit disposal. That is there. But so far as the last part of the order is concerned, Mr. Mahapatra is right that he has been given liberty to file the application, and accordingly he has filed.
My lord, liberty was granted by this court.
So this is to be adjudicated, this interim application,
yes,
whether the restitution of possession is to be made or not.
Yes.
So you have already filed,
I have filed
a counter to this interim application, and what you want to file?
Region of some imputations were made, which is not based on any document or anything.
Lord, may kindly see the first part of the apex court order also. We dispose of this specially petition by reserving liberty to the petitioner herein to file an application before the appellate authority seeking restitution of pending disposal of appeal. No application has been filed, my lord.
But that is
actually what is the total
On
meaning of
merit,
no no no
on merit, my friend.
no 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 12, the Supreme Court says you file an appeal and an application as well, interim
Appeal
application
was
as well.
already filed.
Till the interim application is disposed of, this court can entertain and pass the order. That is the long and short of the.
I do not accept the proposal which my lord put forth.
Kindly read it from the beginning. You read it from the beginning. If you read it, it says that you have to move an appeal as well as approach an application, move an application for interim directions. Till that application is disposed of, this court can protect you.
Now your lordship may examine the scope of the appeal. Appellate authority only to see that whether the legality and maintainability of the appeal.
Otherwise,
And the appellate authority has no jurisdiction to restore the possession which has already been executed in pursuant to the order passed by the.
All right, Mr. Mahapatra, we are not going all to this. We just want you filed interim IA number so and so. This is an application for what is that IA number is 17
14980
17647 of 25 for an appropriate application in which prayer has been made by the petitioner to permit Archana Nag is a lady, so to permit her to use and reside in the property from which she has been evicted till the final disposal by the appellate tribunal, TMLA, of the so and so filed and so and so by receipt. The appeal has been numbered in the meantime. It is stated by Mr. Mahapatra that the appeal has already been numbered as. Please give that in a slip too. Okay. Stop. Mr. Gopal Agrawal, Land Council, appearing for the Union of India, Senior Advocate, Land Council, appearing for the Union of India, Bracketary Enforcement Directorate, has already filed counter affidavit, copy of which has been served on Mr. Mahapatra, Land Senior Advocate, who seeks some time to file rejoinder to such criminal counter affidavit. List this matter on Kebe Rakhiwa phone.
Next week, any day, your lordship.
All right. তাহলে 26 তারিখও রাখি দଉଛୁ ଆଉ time ଫାଇମ ନେବେନି ତ list this matter on 26 ଅସୁବିଧା ଅଛି ନାଇଁ ନାଇଁ ସେ ଯୋଉ ବେଞ୍ଚ ହଉଛି ଗୋଟେ ସ୍ପେଶାଲ ବେଞ୍ଚ ମଙ୍ଗଳବାର ଆଉ ବୁଧବାର ସେ ଅଲଗା
otherwise 25th
ହଁ ଆପଣ 24 26 ଆଉ 28 3 ଦିନ ଭିତରେ କୋଣ କୋଣ 24 all right 24
give name of your instructing council.
The 24/11/2025 on the mana council mana ko na likhi dega. Yes sir.
Copy be served beforehand so that it necessary rejoin the so that I can take inspection.
Yes. In advance to the Mr. Agrawal. Yes, next.
Item 10.
My lord. In compliance of my lord's order, I already deposited the amount of same.
The Land Council for the state has produced the receipt of the High Court Bar Association showing deposit of rupees 10,000, which is taken on record. Yes. Now you have to argue the matter.
The matter is already disposed of.
Disposed.
10,000 costs are
already okay. Yes, next.
Item 12.
Item 12, you have to refer the matter for mediation after hearing. But you can discuss same adamant attitude has been shown by OSFC. They didn't appear before the mediation board.
But the Your Lordship directed them to file affidavit. They also evaded the same by filing a affidavit which is not in consonance with Your Lordship direction.
Send the record of this one to them. Because the issue notice to the
You must may hear and dispose of the matter on merit.
fixing a date of appearance submitted report. Who appears for the OSFC and that Mr. Naik?
Yes,
that
PK Naik. Prashant
PK
Kumar
Naik. So the what is that report? Mediation report.
Mediation report is there.
All the opposite parties are absent, despite several sittings. No swan.
It says the petitioner is counsel are present, the opposite party are absent, and despite several sittings, no mutual.
No, we are asking that managing director to appear.
That's what in one matter we have asked the managing director to appear. On that day, this matter he could explain.
When the matter was listed on 28/7/2025, in presence of the London Council for the petitioner, so also the London Council for the OSFC, we thought it proper to refer the matter for mediation. And accordingly, the registry was directed to send the records of this case to coordinators of the Orissa High Court Mediation Center, who on receipt of the same was asked to issue notice to the parties concerned by fixing a date of appearance and submit a report before this court by end of August 2025. Mr. Mishra and senior advocate submits that even though from the side of the petitioners steps were taken, but in spite of service of notice on the opposite party, no one appeared.
On the first date we have appeared. On the first date,
no one appeared on the for which the mediation became unsuccessful. On perusal of the mediation report, also it indicates that the petitioners were present, but the opposite parties were absent. And no, despite several sittings, no mutually acceptable settlement could be arrived at. In view of such a report and the contention raised by the Land Council for the petitioner and senior advocate appearing for the petitioner, let the managing director of Orissa State Financial Corporation appear in person before this court on
general manager
26th of नहीं आज ये किस तारीख होगी आज 17 ना so let him appear on 21st
general manager
24
general manager instead of managing director
24 of November 2025 in person है ना
he was in
the registry shall send the copy of the order to the ସେଟା କୋଉ ଇଏରେ ଭିତରେ ଯାଉଛି ମଧୁପାଟଣା ବୋଧେ ନା ଚାଉଳିଆଗଞ୍ଜ police station
ମଧୁପାଟଣା
ହଁ
ସେଇଟା ବିଲ୍ଡିଂ ସେଇଠି ଅଛି ଆଉ
ମଧୁପାଟଣା to the IAC of Madhupatna police station, who shall serve a notice and along with a copy of the order on the managing director to remain present on the date fixed. Matter will be taken up at 10:30 a.m.
General manager
10:30.
My lordship, I prefer general manager.
Because the LD is available or not, that it will take it. Yes, yes. So let him serve the notice. No liberty.
First day, first day on 21st August 2025, you appeared. You yourself short time. Thereafter, you wrote.
No.
That's the
No, we
proceeding.
appeared, they did not appear.
No.
On the next 2 days, they appeared.
Managing director को assure करिया को पड़िबो बस गला काम छिनला yes
Right.
next item yes item 13
Item 13.
Item number 30. Joshua directed to explore the opportunities whether they can be regularized by the state or not.
which order
Order number 33, my lord.
अच्छा 4825
4/8/2025.
please paste that order have you got the copy of that order ठीक है पढ़ी जाऊं क्या कर देवे 4/8/2025 order
The last part would be relevant to the last part. I'll start with the
at this stage
at this stage, Mr. Balakshmi, they will on this.
should seek instruction as to whether one-time policy decision for the purpose of regularizing these candidates
could be
will be worked out or not. Yes, so what is your instruction? Mr. Purohit also, the Land Council for the university pointed out that in spite of repeated letters being sent to state government for the purpose of regularizing these candidates, as against the huge number of vacancies, there is no, yes. Where is Mr. Purohit? Whatever like.
That could not be acted upon in just requested.
Accordingly, order number 34, my lord, has snubbed a copy of the interim application.
And the very inception was not according to the they could not be regularized as per the
3704 of 2025.
Have you received this instruction?
Just now, my lord, just as I received it, I have just have a glance about this. I have the impression as if they are sitting over the order of this honorable court. They said that we cannot do this. Nobody asked for their mercy. The honorable court wanted to know whether as one-time settlement, since the university has already made number of queries with the state government that number of posts are available, and they have made by a resolution upgrading the post of executive assistant as junior assistant, and that has not been acted upon. That is why your lordship wanted to know that at the one-time settlement.
They have stated, Mr. Dotto, in the last paragraph that in the absence of any statutory provision or legal mandate, and in the light of the facts and circumstances delineated hereinafter, the claim of the respondents to equate their purely temporary and stopgap arrangement with regular appointment against sanctioned post of junior assistant is wholly misconceived, devoid of merits, and untenable in law. Accordingly, the one-time policy decision of so-and-so to regularize so-and-so cannot be framed at this juncture. So this is all right. Now you have to go on merit.
Yes,
so,
your lordship can have a look at paragraph 6 for a moment.
Paragraph 6, yes.
Paragraph 6 of that instruction. Since they said that this is pursuant to the amendment made in 2020, all these things happened in 2013, much before the amendment. The amendment came in 2020, that cannot be retrospective.
That can be argued. There is
yes.
Let's move. The in pursuance of the order dated 4/8/2025,
Ms. Subhalakshmi Devi, an additional standing counsel, has produced the written instruction dated 22/9/2025 of the Government of Odisha, Department of Higher Education, wherein in the operative part it has been stated that in the absence of any statutory provision or legal mandate, and in the light of the facts and circumstances delineated above, the claim of the respondents to equate their purely temporary and stopgap engagement with regular appointment against sanctioned post of junior assistant is wholly misconceived, devoid of merits and untenable in law. And therefore, one-time policy decision of the state government to regularize the said employees cannot be claimed at this juncture. As per on 4/8/2020, when the matter was taken off, and submission was made by Mr. Rothol and senior advocate appearing for respondents number 1 to 24, and Mr. Shishir Kumar Purohit, land counsel appearing for the Sambalpur University, that a decision has been taken to appoint the respondents as executive assistant against 23 numbers of vacancies of junior assistant in the review meeting held on 24/6/2028 under the chairmanship of the Chief Secretary of the state. And further, Mr. Purohit pointed out that several correspondence have been made to the state government for the purpose of regularizing the respondents against the huge number of vacancies. We asked the land council for the state to seek instruction whether one-time policy decision for the purpose of regularizing the respondents could be worked out or not. In pursuance of such order, returning for this you see, your chief secretary was present.
Was a signatory to the that committee.
Now you are backing it out.
What do you mean by interim measure, by the way? Interim measures are not for decades.
Yes, sir, I'll demonstrate. From
You
the
employed them in 2008 onwards,
Yes.
saying that it's the interim measure.
It is exploitation,
And
nothing.
thereafter, after 2025, you say that interim measure continues.
Fellowship,
And during pendency of this writ petition, you amend the rule and say that it is applicable.
that amendment is not applicable. I concede to that effect.
Then,
and regarding the inception, I'll place it on merit that the
this is
the
clear
entire
exploitation.
engagement was on temporary basis.
What
And-
temporary means? That's what I'm asking. Interim measure means what?
Your Lordship, there
How
are
do
two
you
things.
how do you define interim measure?
Your Lordship, there are two things. For the regulation one,
So
that
your additional secretary seems to be above the chief secretary.
You say interim measure, and in 2008 onwards, this interim measure continues till 2025. Interim measure, no regular appointment at all.
No, Your Lordship.
When the last regular appointment you have done?
2013, the entire thing started the regular employment, Your Lordship. Assuming that they have filed.
When have you advertised for last regular appointment?
I have to take instruction, and in the present case, 2013.
Not till today. This is complete
Next. We are fixing this case to, let us keep it, Mr. Rokha will fix it on December 1st. We'll hear this matter on May.
1st December, yes, ma'am.
Prepare
As a,
yes.
I've already filed my written notes of submission. I'll just demonstrate the.
Yes, 1/12/2020. Yes,
Much.
next.
Item 14.
May it please you. The establishment of the court, there are two posts, programmer and system analyst. The present petitioner working in the post of programmer since 2014 has sought upgradation of his post to the post of system analyst because since 2016 he has been well.
The Mr. Sharma, you are engaged to assist this court for High Court. Now the pleadings are complete.
Yes.
Okay. Okay. Now, what is your prayer, Mr. Pujari?
Upgradation of the post to the post of system analyst. Your Lordship will can
to upgrade the post of
order dated
programmer.
The wrongly written.
Programmer in the establishment of the High Court of Orissa to the post of
system
assistant.
Order dated 11/7/25 may kindly receive.
Programmer to system
Programmer.
System analysis. Programmer to system.
Who order?
Order dated 11/7/25.
Yeah.
May I place it?
Yeah.
This matter is taken up through hybrid arrangement, video conferencing, physical mode. It appears that in the present case, pleadings are complete. During course of argument, Mr. Pujari, learned counsel for the petitioner, placed Rule 14 of the Odisha Information and Public Relations, Technical and Non-Technical Service, Method of Recruitment and Conditions of Service Rules 2015, in short 2015 rules, which reads as follows. 14A. Recruitment to the post of computer programmer shall be made by direct recruitment in accordance with procedures specified in Schedule 12. B. Recruitment to the post of system analyst shall be made by way of promotion from computer programmers who have completed at least 8 years of continuous service as such. Mr. Pujari refers to Annexure 6, the letter dated 6th March 2020, issued by the Government of Odisha in General Administration and Public Grievances Department to all the heads of department of the state, wherein it is mentioned that where the cadre strength is less than 10, but there is no promotional post and it is not feasible to frame cadre rules to regulate the cadre, the administrative departments concerned may consider to upgrade the post to higher rank by keeping adequate residency period to fill up the said upgraded promotional post. The concluding paragraph of the said letter reads as follows. In order to overcome the above difficulties, it has been decided by the government that the respective administrative departments shall take immediate steps to frame cadre rules under the proviso of Article 209 of the Constitution of India in respect of the cadres having no cadre rules for smooth management of the said cadres where the cadre strength is less than 10 out. There is no promotional post and it is not feasible to frame cadre rule to regulate the cadre. The administrative departments concerned may consider to upgrade the post to higher rank by keeping adequate residency period to fill up the said upgraded promotional post. Learned counsel for the petitioner has also referred to Rule 46 under Chapter 9 of the High Court of Orissa Appointment of Staff and Conditions of Service Rules 2019, in short 2019 rules, which provides as follows. 46. Other conditions of service, the condition of service including salaries, allowance, retirement age, leave and pension of the employees of the court shall be the same as may from time to time be prescribed by the state government. Learned counsel further submits that in view of Rule 46 of 2019 rules, Rule 14 of the 2015 rules, the prayer of the petitioner for upgradation of the post of programmer to the post of system analyst in the establishment of the High Court is quite justified. Learned counsel for the state submits that though counter affidavit has been filed by the opposite party, number 1, but since nothing has been mentioned about 46, Rule 46, 2019 rules, and the same has not been dealt in the counter affidavit for substantiating the claim of the petitioner, he may be given some time to obtain specific instruction as to whether the petitioner's case can be considered in view of aforesaid provisions under Rule 46 of 2019 rules and Rule 14 of the 2015 rules, as well as the aforesaid letter of the government under Annexure 6. Subsequently, they have filed a counter affidavit
stating that
এই order পরে
pay order for counter their main ground is that in view of the Article 229, under which only the Honorable Chief Justice can claim rules, this Rule 46, this Annexure 6 of the government's AGA department is not applicable. My submission is I have filed a rejoinder. Your Lordship will kindly see. I have given two judgments. One of this Honorable Court, which has been confirmed by the Honorable Supreme Court.
For the purpose of this rule, the administrative department is the High Court.
My Lord, that whatever is applicable to the government employees will be applicable to the state, to the employees of the High Court. That has been held by the Honorable, this Honorable Court, which has been reported in 1994 OLR 2 OLR 17. There the issue was the same, because the private secretaries of the Honorable Judges of the High Court, they sought that they be equated in all for all purposes with the private secretary in the secretariat. And their demand was recommended by the Honorable Chief Justice, Honorable Acting Chief Justice to the government, which was not accepted. Subsequently, the matter was brought before this Honorable Court. This Honorable Court directed that they be granted the same benefit, holding that wherever the rules are not there, all those things which are available to the employees of the state government are to be ipso facto, are to be applicable to the employees of this establishment, the High Court establishment.
Okay.
And that has been, I have given the judgment, both the judgments. That judgment and also the judgment of the Honorable Apex Court upholding the judgment. May I please relevant portions of the judgment?
Vibhuti Bhushan.
My Lord.
Vibhuti Bhushan Mahapatra.
My Lord.
Which para?
I am submitting.
Jump.
Your Lordship will first see page 7 of the rejoinder.
But when we pass this order,
My Lord.
the State Council made a submission before us that the counter affidavit has been filed, but nothing has been stated about Rule 46.
Only one para 9 they have made a submission
No,
that it.
That was the submission.
Yes, my Lord.
Same
My
has
Lord.
not been
My Lord.
dealt in the counter affidavit.
My Lord.
So therefore, he wants to obtain specific instruction as to whether the petitioner's case can be considered in view of the
My Lord.
Provision under Rule 46.
My Lord.
So obviously the state took time. By that time, I think Mr. Sharma had not.
No, he had not been engaged.
So what is your instruction on this? Have you gone through the order dated for 11/7/25?
We have a, in fact,
11/7/25.
in fact, that counter, my Lord, that counter.
Filed by the High Court.
By the High Court.
No, right. That in that counter affidavit, nothing has been stated about that particularly.
Para 9. In para 9, they have stated that Rule 38(3) and 46 of the High Court of Orissa Rules 2019 have no relevance to the facts of the case. That is the only thing they had stated.
The counter which you have filed now.
First counter.
Page 9.
Second counter of that order.
I filed counter, yes,
subsequently,
order dated 11/7/2025. The counter which I filed is subsequent to your Lordship order dated 11/7/2025.
No, then it's all right. So that we want to know. That then it's all right.
That is on 19/9/2025.
19/9/25.
There you have dealt this.
I've dealt to this.
Okay. Then it's all right. We thought that you have not.
Only
Yes, sir.
Deji, copy Deji.
So now, so far as this 14A, which we have referred in that order dated 11/7/2025, there is no dispute that this programmer have been appointed by way of direct recruitment.
Direct recruitment.
So there is no dispute.
No dispute. And since 2016, he has been discharging the function of this system analyst and also the programmer.
All right. So
more than 8 years.
This is in accordance with so and so. And then it says that so far as to the post of system analyst is concerned, by way of promotion. So, but one criteria has been given that it should be at least 8 years,
8 years
continuous service, and it has been completed. So,
but High Court says that MSCP has been given.
MSCP
on 10/3/2024. Therefore, upgradation is not required.
And both the post also that
And there is a specific bar also, madam. If your lordship sees the 2019 rule, there is a specific bar under rule 39. 39. The specific bar for upgrading a particular post. So wherever the upgradation is not possible, that's why rule 40 is there.
MSCP.
Yeah, rule 40 is there. That's why, madam. 39 puts a specific bar. 40 gives MSCP. So he has whatever he has availed in the year 2011, and the salary which now is drawing.
That is
the
10,
pay, say,
10 years,
10,
20
20,
years,
30.
30 years.
10, 20, 30. And the rule says, my lord, after availing this, there is no change in the designation. 2017 rules, my lord, Odisha revised scale rule says there is no change in the designation. And now the pay scale in which he is placed is equivalent to that of the system analysis.
After getting it.
Is system analysis, yes.
My answer would be, your lordship will kindly see annex of 8, page 25 of my agenda. One, Ajay Kumar Mahanti, after being granted MSCP, has been promoted. Subsequently, he has been promoted, upgraded. Page 25 of my agenda mechanism. I have given that copy. The post of assistant protocol officer, which is made by Sri Ajay Kumar Mahanti, is hereby upgraded to the cadre of assistant registrar in the scale of pay of so and so. And he has been given this after he was granted MSCP.
Both are direct.
When MSCP was given.
Your lordship will kindly see assistant protocol that the statement made in paragraph 8 and 9 are unacceptable. A protocol officer of this High Court establishment was granted MSCP and also was granted promotion.
Where is it?
I have given the promotion order.
No, this is of the year 2017.
Well,
but you say that in 2019 that hurdle came. What he is pointing out.
39, rule 39 and 40.
19.
Of 19 rules. 2017 it is given, no problem.
No,
but 19 they are facing the trouble.
And the revised rules also came subsequent to this order. Odisha, what is the rule 2017? That also came into existence.
So this Ajay Mahanti might have got that 8 years, etc. prior to that 2019. So there was no hurdle, but you had not done that. And when 2019 rule came, that amendment came, whatever. So how can you say that you are claiming that somebody else has been given? They can segregate the case that you are standing in a different photo. Where is that 2019? Have you mentioned it in your counter?
Yes. Regarding what, madam?
This 2019, that 2 sections which you are referring
39, 40, yes, madam.
In which paragraph?
First of all, my lord, rule 6, my lord. If your lordship sees the rule 6 of 2019.
Para 7.
High Court rule, sir.
Para 7 you have been.
Sir.
Para 2.
Just show us the rule first.
So rule 6, my lord.
Rule 6 of
6 of the 19.
Directly.
Then my lord, may I say?
Yes.
Let it come on an because 63 rules, whatever issues were, whatever subsequent orders were passed, that has to be looked in.
And you want time?
My lord.
All right, let us see.
Because that is required whether any order was there.
All the rules will be compiled next time. Just
That
seeing
would be
here.
better.
Yes,
Right from the beginning, that would be
Yes.
better.
Compilation.
Better. So we are not indicating also the name of Mr. Sharma is to be reflected in the report.
Yes.
So simply we are adjourned.
Yes.
And you will deal with para 7 and 8 of their counters.
Since
that issue whether 17
already
that was in terms of 63 rules or 2019
was the Register Judicial Orissa High Court, the name be reflected in the resolution. And so, Mr. Basudev Pujari, like counsel for the petition is present.
My name is there in court list. Sir, ये भी High Court द्वारा सही चौथी है associate of mine to assist me.
With Mr. Sangram Jena. All right. Mr. Pujari seeks for an adjournment. Put up this matter. Kebe Rokia Kon.
next week.
Next week we have fixed already.
Subsequent.
First week.
First week re 1 तारीख रे 3 तारीख out 3 तारीख 3rd of December 2025. Yes.
Item 15.
It petition is filed challenging the judgment of the Central Administrative Tribunal. But matter is very short regarding fixation of cut-off duty. Sorry, cut-off date. In order, Lordship, kindly see page 87.
You are for the
petitioner.
I am for the respondent.
Which respondent?
Private respondents are there, but they are not appearing.
Railway.
Private respondents are also there, but the notice has been made sufficient. But
nobody is appearing.
Nobody is appearing since last
week. We have also mentioned that in 8025. So, Mr. Mishra, your prayer is to set aside the order dated 5/1/24.
5/1/24 of the
5/1/24 order is annexure.
That is annexure
9.
9. So, my lord, may I permitted to place it to page 87.
I just want to know from one thing from you that this writ petition has been filed by 15 petitioners, right?
Yes.
And all of them
were the applicants before the
apart
tribunal.
from the 15, there were more 5 in numbers.
Yes.
Now they have not come here.
They have not come here.
Okay. So, what was your prayer in the original?
Prayer, my lord, if you look at the page 87, the tribunal has referred to prayer and then it's very short matter.
No, just a minute.
Prayer, my lord, also may
in every such matter, we insist that you should file the entire pleadings before us. Even last week also we passed the order that
entire pleading before the tribunal,
so that we can know down. So if you have got the original application and counter affidavit must have been filed also.
Yes.
And regional
I'll file it, my lord.
So that would be better.
Yes,
if you file it, we can take up.
Yes, madam.
So can you file and by within this week? Is it available with you?
Available must be available. Yes, available.
Though in this petition, challenge has been made to the order dated 5/1/2024 passed by the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 199 of 2019. But the pleadings before the Land and Central Administrative Tribunal has not been brought before us, which should be necessary for proper adjudication of the writ petition. Mr. Mishra Manoj Mishra and senior advocate appearing for the petitioner submit that during course of this week you will file the entire pleadings and the matter may be taken up.
28th.
This matter 28 there is some problem, so any other day.
Then 3rd December.
3rd December 2020. All right.
My lord, copy টা সব করিবে এটা
প্রিডিংস টা আপন পার প্রিডিংস ର কপি নাই
না
অরিজিনাল আপ্লিকেশন সি ফাইল করতে হবে কাউন্টার আফিডেভিট আপন ফাইল কলে রিজেন্ডর সি ফাইল কলে আপন কোড গলে কোন গলা থোড়া অলরাইট লেট এ কপি অফ দিস এমপি
second copy, second representation we have. First je tak par nahi.
অলরাইট ডাইরেক্টলি হ্যাঁ আপন কেতে নম্বর
6000
সেকেন্ড আসিও পর তারি সঙ্গে আসিও সেই 3 তারিখ
Ha sangare asu.
ଆପଣ ଆପଣଙ୍କର କିଏ ଜଣେ ସିନିୟର ଆଡଭୋକେଟ ଆପଣ ପ୍ରେସ୍ କରିବେ ଆଉ କଣ ଦରକାର ଆପଣ ଜଷ୍ଟ ଆସିକିନି ଆରାମସେ ବସନ୍ତୁ ଦେଖନ୍ତୁ ଆପଣ ପ୍ରୋସିଡିଂ ଯାହା ଇନଷ୍ଟ୍ରକ୍ସନ ଦବା କଥା ଦିଅନ୍ତୁ ମିଷ୍ଟର ମିଶ୍ରଙ୍କୁ ହେଲା ଦିସ୍ ମ୍ୟାଟର ବି ଲିଷ୍ଟେଡ୍ along with so on so yes next
Item 16.
The matter is referred to the mediation. Mediation became successful. The report is there.
Successful. They have sought for a non-due certificate. Bank has provided because of they have not given the certified copy of the DRAT. And
now, in terms of the mediation report, will disclose.
I am email.
What is found by?
As for the mediation को refer इतना who date है
mediation that was referred on 28/7/2025. I am giving
as for the order dated 28/7/2025 we refer the matter to for mediation and the mediation report has come which is dated 7/11/2025 which shows that the mediation has become successful. Accordingly, in this petition, prayer has been made. The court therefore, this matter is disposed of in the terms of the compromise effected between the party. Terms of the mediation disposed of. Yes, next.
Item 17.
The petitioner is the railway employee, my lord. Is approach cat, my lord.
He is appearing for the other side. P.K. Pari and Kaivalya Panda. Union of India ପାଇଁ railway ପାଇଁ Mr. Pari ଥିଲେ ପରା ଅଧିକା
ଯେଥିଲେ ସେ କାହାକୁ ଦେଇଛି ସେ ଇଣ୍ଟରେଷ୍ଟ କରିଛି କାହାକୁ କହୁଥିଲେ ସେ ଆଗରୁ ଗୋଛାତ ଥିଲେ ତାପରେ ମାନସ
ରିଜେଣ୍ଡରି ଫାଇଲ କରି ସାରିଲେ
ମୁଁ ସବୁ କରିଦେଇଛି ମାଇ ଲର୍ଡସ୍ ଅର୍ଡର ମାଇ ଲର୍ଡସ୍ ସ୍ପେସିଫାଇଡ ଆଗ
Mr. Pari
new office that terminal that is the Arika teaching a session
Yes, Mel.
This is item number
18.
17. So the name of Mr. Kaivalya Panda is appearing. Who is he? Where is he?
Where is my land CGC? There is held up in another court. No, Lordship pass over it. Just pass over.
ଆଉ ତ ପାସ୍ କଣ
କଣ ବର୍ତ୍ତମାନ ପାସ୍ ଓଭର କଲେ କଣ ସେ ଯିବ ଆଉ ଗୋଟେ ଡେଟ୍ କୁ
tomorrow
dedicated bench.
So all right, it will be listed day after tomorrow because we are not passing any order, so automatically it will be day after tomorrow.
But he is only also yelling, my lord. So that's why my lordship can consider compassionate. Oblige, man.
କୌଣସି କିଛି ଲେଖିବେନି ତା ଦେହରେ ସେ ଅଟୋମେଟିକ ପଳିବ next
Item 18.
Lordship, implementation of this second National Judicial Pay Commission is also.
Again, who is to argue this matter?
But item 18, we receive an instruction accordingly. We file affidavit. So give 2 weeks time.
Counter affidavit not filed, acha.
The Honorable Supreme Court has already categorically directed to implement the Second National Judicial Pay Commission. In fact, it is applicable to the Industrial Tribunal judges presiding officers, which is no res integra as per the judgment of.
Who are you?
I was working in this as the presiding officer as industrial tribunal judge.
My counter will suffice their problem. Let give some time.
Mr. P.K. Parhi, and Deputy Solicitor General submits that he has received what you have received, parawise comments or what? Or affidavit?
Only instruction. Only file affidavit.
He has received the necessary instruction and he will file it the same by way of an affidavit.
Yes.
এই সপ্তাহে ফাইল করি
10 days time.
Within 10 days. Let a copy of this send the County Land Council for the petitioner. Matter be listed in the if you want to file any representative in the files, we are listing it in the commencing from 8th of December 2025. Yes.
Item 19.
Yes, Srinivas Mahan.
Yeah. Restoration matter.
ITC order dated 14/5/2025.
Notice to the opposition
OP for already appeared.
Just a minute. Opposite party requisites opposite party पर कौन हला? असला की track report चलेला. Notice.
My lords, I am appearing on behalf of OP number 4.
OP number 4?
Yes, my lords.
All right. So writ appeal केवे dismiss इतला?
My lords, the writ appeal was dismissed on.
Non appeal sector. What do you say?
My lords, the writ appeal was dismissed on 28/10/2000.
Restored and the matter be hard on merit also.
My lord, this is the third round of litigation.
Writ appeal third round of litigation.
My lords, they filed the writ appeal was dismissed for non-appearance. They filed one CMAPL 596 of 2022, which was also dismissed because they did not comply with the court's order on 5/10/2023, and this is the third round of litigation.
Just a minute. Writ appeal was dismissed for non-prosecution on 28/10/2022. तापर कौन हला कौन तो?
My lords, then they filed a restoration application for CMAPL 596 of 2022. The honorable court directed them to.
Where is your ଆପଣ कौन ପାଇଁ service ହେଲା notice ଆପଣ କିଛି why are you not bringing all these things?
Can you see page 10?
You have disclosed all these things earlier. Also, you have proved and all these things.
Page 10 is the impugn order.
Page
10.
Page 10 of the
Present application.
You are sure.
3 days.
Law and Council petitioner undertakes to remove the defects within 3 days. Failing which CMAPL shall stand dismissed without further reference. Okay. तापर कौन हला?
That is how the CMFL got dismissed.
और दिले नहीं defect
removal anything.
Certificate copy we can't unable to obtain certificate copy.
नहीं ठीक है जी तापर तेणु 596 टा dismiss ହେଇଗଲା.
Yes, my lord.
ତେଣୁ ବର୍ତ୍ତମାନ ଆପଣ ଯୋଉ CMAPL ଫାଇଲ କରିଥିବେ ସେଇଟା ଆପଣ ରିଷ୍ଟୋର କରିବେ ଆକୁ ନା ଆଉ
IA କଲି 596 ରେ IA ପୁଣି କଲି restoration ପାଇଁ.
ଏତେ ଜିନିଷ ଆପଣ କରି ପକେଇଛନ୍ତି କାଇଁ କୁଆଡେ ଗଲା ଡେଟ୍ ଚାର୍ଟ ଫେଟ୍ ଯାର ଅଛି?
14 ହଁ
ସେଇଟା ବି dismiss ହେଇଗଲା.
नहीं सेटा डिसमिस है
appropriate application of
page
14 and 15.
Page 14.
हाँ 28/3/2025 हाँ period the kind manner to this one अच्छा जो आचरण कौन सा होता है CMAPL was listed on phone on
appropriate
अच्छा office note as per SR were removed nor any application was filed for extension of also. Accordingly, the matter was listed before this being posted to the office. Okay. File listed for dismissal. No. When council was submitted, the revenue within the stipulated so also. You would think they have been filed. The said application was filed on the admittedly.
and this court has no other option to dismiss the CM appeal in terms of the CM appeal stands dismissed. The petitioner may file the appropriate application after obtaining the certified copy of this one suit. आपने कौन हला?
Thereafter, file this application or restoration petition 116, and the notice was issued to private opposite party. That's for
तो वर्तमान होची एते पता सब हे गलानी जे
Liberty is granted basically.
Liberty is granted, but not through IA. That remedy could not be granted through IA. That
मेन
is how.
रीट अपील ले प्रेयर कौन पिला?
Read appeal prayer gram panchayat.
The shifting of Gram Panchayat head office.
अच्छा
Mainly head of survives. Anything survives in that.
ତେଣୁ ଆପଣ ବର୍ତ୍ତମାନ ମିଷ୍ଟର ମହାନ୍ତି ଅଛନ୍ତି ବାର୍ କାଉନସିଲ ଆମର ବାର୍ ଆସୋସିଏସନ ରେ କେତେ ଡିପୋଜିଟ୍ କରିବେ ଆମେ
Come to the real point.
କମ୍ ଟୁ ଦି ରିଅଲ ପଏଣ୍ଟ କାରଣ ଆମେ ଗୋଟେ କହିଥିଲୁ ସେ ବାର୍ ଆସୋସିଏସନ ସେ କର୍ମକର୍ତ୍ତା ମାନଙ୍କୁ ଯେତିକି ଅଛନ୍ତି 25 ଜଣ ଷ୍ଟାଫ୍ ଅଛନ୍ତି ତାଙ୍କୁ 1000 ଟଙ୍କା ଦେଇ 25,000 ଟଙ୍କା ଗୋଟେ ମ୍ୟାଟରରେ ଡିପୋଜିଟ୍ ହେଲୁ କଲେଣି ସ୍ୱତଃପ୍ରବୃତ ଭାବରେ କେତେ କରିବେ କୁହନ୍ତି
ତାର ଏଟା କମି ଯାଉଛି ସିନା ସେ
ନାଇଁ ମିଷ୍ଟର ମହାନ୍ତି ଅଛନ୍ତି ସେ ବଢେଇବେ ସେଟା 25,000
ହଁ ସେ ବଢେଇବେ ହଁ ସେ
ସେଥିପାଇଁ କହିଲି ସ୍ୱତଃପ୍ରବୃତ ଭାବରେ ତେଣୁ କେତେ କୁହନ୍ତୁ ଆମେ କରିଦବା ତାପରେ ରିଟ୍ ଅପିଲ୍ ଶୁଣାଣି ହବ ନାଇଁ ନା କହିବା 25,000 ତ ହେଇଥିଲା ତେଣୁ ଆପଣ
ଯିଏ କହିଲେ voluntarily
ଯିବେ ନା ତାପରେ ଯିଏ ନେକ୍ସଟ ଆସିବ ସେ ତା ଉପରକୁ ଯିବ ଏମିତି ହେଲେ ଆମର ବାର ଆସୋସିଏସନ ପିଲା ଗୁଡା ତ କିଛି ବେନିଫିଟ ହେବେ ଆଉ ଏଇ ପିଲା ଏଇଗୁଡାକ ହଉଛନ୍ତି ସବୁ ଏମାନେ ତ ରାଜନୀତିଆ ଲୋକ ସବୁ ତ ସେମାନେ ଯୋଉ ଚାହୁଁଛନ୍ତି ଗ୍ରାମ ପଞ୍ଚାୟତ ସିଫ୍ଟ କରିବା ପାଇଁ ତେଣୁ ଉଦ୍ଦେଶ୍ୟ ଅଲଗା ପ୍ରକାର ଥିବ ସେ ଛିଡା ହେବେ ସବୁ କମିଂ ଇଲେକ୍ସନ ଫିଲେକ୍ସନ କୁ ଆଖି ଆଗରେ ରଖିକି ସବୁ କରିଛନ୍ତି ଶୁଣିବେ ଆପଣ କହିଦିଅନ୍ତୁ ଆଗେ ରେଷ୍ଟୋର ହେଇଯାଉ ଆପଣ ଯାହା କରିବେ ସେଇ 25,000 କରିଦିଅନ୍ତୁ 25,000 କରିବୁ ରେଷ୍ଟୋର
ଗୋଟେ ଲିଷ୍ଟ
ଆଉ ରିସିପ୍ଟ ଆଣି ପ୍ରଡ୍ୟୁସ କରିବେ 1 ୱିକ୍ ଦେଇ ଦଉଛି 1 ୱିକ୍ ଦେଇଦେବେ ତାପରେ ରିଟ୍ ଅପିଲ୍ ରିଷ୍ଟୋର ହେଇଗଲା ତ ଆସାଇନ୍ ବେଞ୍ଚ କୁ ଯିବେ That's all. ବାକି ସବୁ ପହରଦିନ ନିଆଯିବ Please give it next week anything.
And that I may be pardoned to mention. One, I have filed an IA application in the jail criminal appeal. Your Lordship was pleased to grant him the bail, and he had also surrendered in time. And after surrendering, he is in custody the last 8 months. So I pray.
You have filed another application. Please give it.
IA has been filed in a criminal appeal for interim bail. For interim bail.
criminal appeal, I for bail.
This is been custody for about 11 years.
Please be here. Item.
Weekly daily, second half, item number 1.
Life improvement.
Yes, sir.
Admit call for the madam bring this for my question.
Now, phone number and email ID, everything.
You are engaged as an amicus curiae in this petition. So we are in this jail criminal appeal. So give your name so that and we are asking the registrar to supply you the prisoner's petition and the judgment. And yes, next.
Item 2.
Life imprisonment.
Zero to 34 life.
You are there in that panel now? Are you there in the panel? You are having 10 years of practice, no? So give your name. Please come. Delay one second. Admit for this. Yes.
Item 3.
My lord, where for bail, I number 331 2025.
You have received the paper book copy.
My lord.
Have you received?
Yes. Yes, under section 498, 304B, 201 and 34.
My lord, where for bail, I number 331 2025. Offense committed 498 304B 34. My lord, accused person, 3 accused person. Nanda Malik, Srimati Saudamini Malik, Prakash Malik. My lord, for RI.
PW14 is the doctor.
My lord, no, I
died
witnessed.
out of burn injuries.
Yes.
PW14 is fine.
Transport report.
Doctor?
PW14.
PW15 also doctor.
But from
My lord, the case of the persecution is sought in that the marriage between younger sister of the informant and accused and Prakash took place 11/3/2015 was the occurrence. In
Don't
Karen
read,
Temple,
madam, don't read it. Tell us the case.
when the marriage took place? When the marriage took place?
Marriage.
marriage 2-3 months.
2-3 months prior to the death of the deceased.
My lord.
Marriage was on 11/3/2015.
11
11 March 2015.
11/3/2015.
My lord, 10 years.
And when the death took place?
Yes, took place.
So 14/5 is the
13/5 within 2 months of March.
3 months.
So what the family members have stated?
My lord, mother, father, mother.
What they have stated? Who is father?
Nanda Malik.
No, PW?
No, Malik is the father-in-law who is the accused.
ମାନେ ପୁଅର ବାପା.
He is the accused. He is the appellant.
Accused.
Who has divorced from
PW5
the
is the
side of
informant. PW5 is the informant.
From 14th August 2016, in the meantime, Lordship pleased to allow the interim pledge 2 times. 3 months or twice, and 15 days once. That was he in time surrender, and I will annex the surrender certificate also.
Got the conduct certificate during this interview.
How many years he was there?
My lord, 8 year, 8.5.
So, no, you are granted interim bail. How many occasions?
No, twice, 3 months or 15 days. 3 months or 15 days. Now was 9 years, with them, bad
19 February 25. 19 February 25.
19 February 25.
Then 6 May 25.
Thor dala, 3 thor keteବେଳେ? ଆଉ ଗୋଟେ ଥର କେତେବେଳେ?
6/5/24.
Yes, sir.
କେବେ?
6/5/24. Thereafter on 19 February 25, then 6/5/25.
ଯେତେବେଳେ ଆମେ past ରେ ମଧ୍ୟ ଦେଇଥିଲି ସେତେବେଳେ we have mentioned that he was taken into judicial custody since 14/8/2016. जोटा फास्ट आमर थिला 6/5/24 ऑर्डर तेणु से पाए 8 वर्ष ही 8 वर्ष more than 8 years old.
Yes.
Now thrice he has been granted bail and he has not
Misutilized.
utilized it.
IPS.
Are the learned counsel for the petitioner and counsel for the state? It appears that the petitioner is in judicial custody for more than 8 years. And he was granted interim bail price. That is by order dated 6/5/2024 for a period of 3 months. By order dated 19/2/2025 for a period of 2 weeks. And by the order dated 6/5/2025 for a period of 3 months. And after availing the interim bail period, he surrendered at trial. The Learned Counsel for the state has produced the written instruction received from IIC R. Udayagiri Police Station dated 14/11/25 to show that during the interim bail period, there was no petitioner had not involved himself in any criminal or antisocial activities. And there was no awkward situation arose during his staying period in his village. The written instruction is taken on record. Considering the submission made by the Land Council for the respective parties, of detention in judicial custody, and conduct of the petition while on interim bail, keeping in view leti case, bail is allowed.
Item 5.
In item number 5, the Lordship has called for a report regarding his mental health condition as well as the conduct in jail. The his conduct is satisfactory, he has to place him before the psychiatrist board to know, ascertain whether he has mental disease or not. For that, I request some more time.
His mental health condition.
Yes, Your Lordship. For that, and the other day, I had produced the report regarding his physical health, Your Lordship. For that particular thing, Your Lordship has called for a man over the page. Your Lordship.
He works as a night watchman inside jail.
Yes.
He has good relationships also, including also regarding the mental health condition. Our present health and फैमिली मेंबर आछुंदी तांको मीट करछि तो वाइफ को आछी पिला माने भी आछुंदी भौणी आछी रेगुलर इंटरवल ले
यस
केते दिन रहिलानी
8 years 10 months 15 days milad as in 7/11 8 years 10 months 25 days milad as in
first aid certificate is on record.
Whether your bail application was earlier rejected.
No, milad was first time moving this application. It's early.
His custody is around 8 years, 11 months, 27 days.
बाकी आउ कुहाइतला जो इंस्ट्रक्शन आनी हो criminal antecedent.
That is already on record. Flag B.
Is there any criminal antecedent?
No.
No.
Flag D is the only complaint is a man from Jharkhand. It's not a local man.
Local
And
security milad has also been
the
verified.
manner in which he has committed the crime. For that reason, the psychiatric angle was been looked at.
No, securities aspect has been verified.
Yes.
Local security and
Yes, that has already been done.
So who are those two sureties?
I have filed details of the sureties. Thereafter, your lordship have direct.
Right, documents of na da likhiwa padibo na jodi
local
अन्य security dala hobani.
Flag E.
Flag
E.
E. Cha. Ipodas Hamsia. Yote. Yote milad Dolo Govindo.
And Dolo Govindo Bhai.
The Manutin so Sundar Rodacha. The documents are so also. Are the Land Council for the Petitioner Land Council for the state. Today the Land Council for the state has produced the written instruction received from Superintendent Jail Sundargarh dated 17/11/2025. It shows that the petitioner is in judicial custody since 22/12/2016 and during the confinement, his conduct and behavior towards the jail inmates, jail staff, and in general was satisfactory. And he had not committed any jail offense and is a rule-abiding inmate. He is working as a barber from night watchman inside jail, and he has good relation with his family members, including his wife, children, and sisters, who used to come in regular interval to meet him in district jail, Sundargarh. Stop. It has been further stated that the present health condition of the petitioner is good as per the advice of the jail medical officer of the district jail, Sundargarh. Land Council for the state has also stated that the petitioner's custody period is 8 years and 11 months, and there is no criminal antecedent against the petitioner, as has been reported by IIC Rajgangpur Station. Stop. Considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody, and absence of any chance of absence of any criminal antecedent, absence of any chance of early hearing. We are inclined to release the petitioner on interim bail for a period of 3 months, subject to condition that Shibodas Sansia, son of Mohandas Sansia of Kumar Kela, US Rajnagar, District Sundargarh, and Dolo Govinda Vaisa, son of Nakulo Vaisa at Deuri, Pandermal, US Bhasma, District Sundargarh, whose documents have been produced by the Land Council for the appellant and verified to be genuine as per the report of the DSP in charge, Rajnagar Police Station, dated 12/5/2025, shall stand as the sureties for the appellant. Put of this matter on Sushant Soldier, he will file the surrender certificate. Yes.
Item 6.
Order dated 29/10/25, my lord. Call for and conduct in the jail custody, my lord. 29/10, my lord.
Double position. Double.
Lordship has called for a conduct triple as well as criminal antecedent and subject.
What is the period of detention?
Part D, my lord. Part D, my custody certificate 10 years 6 months, sir.
Acha.
10 years 6 months.
9 year 10 months as on
10 months 17 days এটা হচ্ছে রিপোর্টটা হচ্ছে 5/2/2025 obviously 10 years criminal case কিছু নাই jail conduct satisfactory offense কোন
eyewitness to the incident. PW1 is the doctor, PM doctor. PW14 is the eyewitness.
14 বার করে দে ଆଗରୁ ମେରିଟରେ ରିଜେକ୍ଟ ହେଇଥିଲା କି
ଜମା ରିଜେକ୍ଟ ଫାଷ୍ଟ ଟାଇମ୍
ଆସିଲେ PW14 ଅଛି ଏଭିଡେନ୍ସ କପି ଅଛି ଚଉଦ ନମ୍ବର ସେକ୍ସନ PW14 ହେଲା ଆଇ ୱିଟନେସ୍ ଆଉ ଡକ୍ଟର ହେଲା କେତେ
PW1 and 5 the double murder case. May I start with PW14? I know the accused person standing in the dock. They are Biju and Nahaka and Ramesh Nahaka of village Maheshwarpur. They are my stepbrother, being the sons of my father Kulamani Nahaka. My mother's name was Satya alias Lakshmi, who is dead now. I had also a sister named Jamuna. Jamuna and Lakshmi are the deceased, who is also dead now. They died more than 4 years back in our rented house at village Swansa, being murdered by the accused persons. My mother Lakshmi Satya was murdered in Jaipur in the district, married in Jaipur in the district of Koraput to one Rama. I was given birth by my mother through Rama. Thereafter, my mother left her husband Rama and came with me and stayed with the house of my maternal uncle at Manikpur. When my mother was in uncle's residence, Pulamani Nahaka developed acquaintance with her and kept my mother as his wife. Thereafter, I started addressing Kulamani as my father according to the advice of my mother. Since then, I am known as the son of the Kulamani and I am giving identity as the son of Kulamani. Kulamani brought me and my mother my uncle's residence and kept us at Talesur. At Talesur, my mother had constructed a house of her own income, and we resided therein in the said house. Kulamani sold away that these ones brought to the Haripur and kept us there for some time. From Haripur, we shifted to Mundula and the Sunset. Paragraph 3 would be relevant. And on the date of death, my mother and sister, which were in our home at the Bochapoda Paiko Konhaipu, the accused person came to our house about 1 a.m. in the night and called my mother as Bau Bau. When my mother did not open the door, the accused persons unhinged the door and entered into our house. Thereafter, they asked my mother to show them there was father. My mother told that their father is not there in the house. Thereafter, Bijay, who is holding an axe, assaulted my mother. By that axe, and Ramesh killed my sister Jamuna by assaulted through sword, which she was holding. Thereafter, seeing this, I fled away from the house and watched the incident by remaining inside a latrine near the house. After killing my mother and my sister, the accused person went away by bolting the door from outside. Thereafter, when the accused person fled away, I went near the dead bodies of my mother and sister and found them dead. I also
It
found the same
appears persons assaulted two
individually.
different deceased.
Yes,
So far as this appellant is concerned,
Yes.
his name is Ramesh.
Ramesh.
He has assaulted
Ramesh killed
Jamuna.
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 Yes.
What about that man, Vijay, who assaulted on the mother?
My lord,
Huh?
Vijay and
He
they
was
are
absconded
in
for which the
during
trial was
trial, they are on bail, my lord.
Who?
Both are on bail, but when the judgment was pronounced, Vijay was absconded, man.
Okay,
So,
that is why when we saw that the only
Yes.
Ramesh name is there in the judgment. Okay.
But he faced the trial.
He
faced the trial, but
he is absconded since
active
2004.
statement was taken, my lord. When judgment was pronounced, he was absconded.
Case was split up on 26/10/2021 vis-a-vis
So
the
that means X killed one deceased, Y killed another.
Yes.
So what he assaulted this man,
Jamuna.
assaulted Jamuna.
Jamuna.
What is the injury caused to Jamuna?
PM PW5 is the PM doctor.
PW5.
5. Who examined Jamuna.
7 injuries.
7.
But
And
there
on the
one blow.
he dealt only one blow as right.
he says he dealt one blow, then he fled away out of fear.
Who?
The PW is the sole eyewitness.
He fled away.
He fled away from the
Witness fled away.
Yes.
Thereafter,
So
There is no.
who knows that the rest of the blows might have been given that other person, because both are the sharp cutting weapons. So you cannot. There is no such other evidence except this eyewitness. Can you attribute entire blows to this of Jamuna to this man? Because PW5.
Any other witness?
PW12. He says about the previous threatening.
Then only one eyewitness.
Yes. It was 1 a.m. in the night.
There are some lacerated wounds also.
Yes.
Spot wound is there, of course. One on the right eye, so and so.
PW12 says about the motive as well as the threatening given by this accused persons. PW12 will. Paragraph 2, I'll start. Lakshmi was earlier given in marriage in a village in Koraput. She had begotten a son, Tophan, through that person. As that person left Lakshmi and her son Tophan, they came back and they were staying in my parents' house at Makhanpur. After some, she left for village Talesar and lived there independently
This
along with her son.
PW14 is the also
Son.
the informant.
Yes, I'll just
Yes, ma'am.
check. Yes,
Tufan
sir,
Act,
it is
na?
informative.
EW, and you see the FIR. If you come to the second page, second page of the FIR.
Yes.
ଅଛି ନା ମୋର ମୋର ମା ଜଳୁଥିବା କିରୋସିନ
କିରୋସିନ ବତୀ ଦେଖାଇ କହିଲା ଦେଖ ନା କୋଉଠି ତ ବାପା ଅଛି ଏତିକି କହିବାରୁ ରମେଶ ମୋ ମା ର ଚୁଟି ଧରି ତଳେ ପକେଇଦେଲା
ରମେଶ ମାନେ ଯୋଉଟା ଏଇ ଯୋଉ ଅଛି ହେଲା ରମେଶ ମା ର ଚୁଟି ଧରି ତଳେ ପକାଇଦେଲା।
ବିଜୟ ମୋର ମା ମୁଣ୍ଡକୁ କୁରାଢିରେ ବାରମ୍ବାର ଚୋଟ ମାରିଲା। ରମେଶ ମଧ୍ୟ ମୋ ମା ମୁଣ୍ଡକୁ ହାଣିଲା। ମୁଁ ଡରିକି ଘର ବାରି କାନି ଯାଇ ଲୁଚି ଏ ଘଟଣା ଦେଖୁଥିଲି। ମୋର ମା ଗୋଟେ ଗଁ ଗଁ ଶବ୍ଦ କରି ଚୁପ ହେଇଗଲା। ମୋର ଭଉଣୀ ଯମୁନା ଖଟ ଶୋଇ କାନ୍ଦିବାରୁ ବିଜୟ ତାକୁ ପିଟିଲା ଏବଂ ସେ ଜୋରରେ କାନ୍ଦିଲା। ବିଜୟ ତାର ମୁଣ୍ଡକୁ କୁରାଢିରେ ହାଣିଦେଲା। ସେ ମରିଗଲା। ଏହା ପରେ ସେମାନେ ଘର କବାଟ ଲଗେଇ ଦେଇ ଚାଲିଗଲେ।
ତ ଯୋଉ ଯମୁନାର ଆସଲ୍ଟ ବିଷୟରେ ଯୋଉ ଆକୁ ଆଟ୍ରିବ୍ୟୁଟ ହେଇଛି that is not there in the FIR.
ବିଜୟ କହୁଛି ଏଠି
ସେଠି ବିଜୟ କେବଳ ମାରିଲା ବୋଲି କହୁଛି।
In the deposition he says that Vijay assaulted the Lakshmi. In the deposition
no deposition ଆପଣ ଦେଖନ୍ତୁ ଏଠି କହିଲା ମୋର ମା କୁ ଦି ଜଣ ମାରିଲେ।
ଦି ଜଣକୁ
କିଏ ମାରିଲେ ନା ସେ ପ୍ରଥମେ ସିଏ ମାରିଲା ସେ ଯୋଉ ବିଜୟ ମାରିଲା ତାପରେ ରମେଶ ମାରିଲା। କୋର୍ଟରେ ରମେଶ କଥା ମା ଆସଲ୍ଟ ରେ କିଛି କହୁନି
ଖାଲି ବିଜୟ
ରାଇଟ୍। ସୋ ଫାର ଏଜ ଭଉଣୀ ଆସଲ୍ଟ କଥା କହୁଛି FIR ତାର ନିଜର କହୁଛି ଯେ ଓନ୍ଲି ବିଜୟ ହିଁ ମାରିଛି whereas in the court ହଉଛି କେବଳ ରମେଶ ହିଁ ମାରିଛି। so that is the thing। ତେଣୁ ଏଇ ଯୋଉ ଲୋକଟାର କେସ୍ ବେଟର ଅଛି ତ ରହିଲାଣି 10 ବର୍ଷ or the Learning Council for the petitioner, Learning Council for the state, the Learning Council for the state has produced the written instruction dated 17/11/25 from IIC Collegiate Prestige to show that there is no criminal antecedent against the petitioner. Similarly, she has also produced the written instruction dated 15/11/25 from the Senior Superintendent, Circle Jail, Berhampur, to show that the conduct of the petitioner inside the jail is satisfactory. Both the reports are taken on record. From the custody certificate, which was earlier produced before us, it appears that the petitioner has remained in custody for more than 10 years, na?
10.
For more than 10 years. The Land Council for the petitioner submits that PW 14 is the eyewitness to the occurrence, and so far as the petitioner is concerned, who is also the informant in the case. Though in his evidence he has attributed specific overt acts against the petitioner to have assaulted his sister Jamuna by sword, but while lodging the first information report, he has stated that it was Vijay Naik, who was an absconder, assaulted his sister Jamuna Naik. He further submits that in view of the available material on that, there are good chances of success in the case and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land Council for the state, on the other hand, placed the evidence of eyewitness PW 14, so also the evidence of PW 5, who the doctor who conducted post-mortem examination over the dead body of deceased Jamuna Nahat. Considering the submission made by the London Council for the respective parties, nature of evidence available on record, absence of any criminal antecedent, the conduct of the petitioner in jail, the period of detention in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail, allowed stay realization of time.
Item 7.
Yes, madam. Huh? No, have you brought the detention period, etc.?
My lord, the
Huh?
my lord, the petitioner is got arrested on 19/3/2007.
Custody certificate.
Custody certificate. The London Council for the State shall produce IA number 221 of 2025. This is an application for bail. London Council for the State seeks some time to produce the custody certificate and to obtain instruction regarding the criminal antecedent, if any, against the petitioner. So also the conduct of the petitioner in jail. Put of this matter. Go to Saptaha par aanchu, so you bring it in 1st December 2025. And Bhakti Sudha Sahoo and Council for the appellant is present. Yes.
Item 8.
My lord. My lord, therefore, bail I number 120, 2025.
Have you, madam, have you received the paper book?
My lord.
You have also received the paper.
Date of occurrence 14
Just a minute. You have filed an application for bail. Okay.
What's the period of custody?
10 years above.
Have you received the? So give that same problem, same model problem, है ना? ये custody certificate, तापरे CA and jail conduct है ना? Same date रखी देले 1/12/2025. अब IA number टा अलगा अच्छी लिख दे रहा हूँ, है ना? Okay, next.
Item 9.
May I please proceed? IA has been filed for bail. His office understood 302-201 of IPC.
Anichendi? No. Cheese, intelligence, huh? Custody certificate, CA, jail conduct. 1/12/2025. Yes, next.
Item 10.
May I please do this? And that client is aged about 73 years and custody since the date of arrest, that is 6/21.
Custody certificate, CA, jail conduct, 1/12/2025.
My lord, may I pray one? My lord, at the appellant is aged about 73 years. My lord, more than 70 years. My lord, as per
that application is not coming. There is a separate format is there.
I contacted the concerned DLSA. They told me as per Honorable High Court order, we will provide this.
No. Acha, lekhi diyantu. Have you mentioned anywhere in your petition that is aged about?
Yes, I mentioned in my bail petition.
It is mentioned in the bail petition that the petitioner is aged about 73 years. The London Council for the State shall obtain specific instruction on this aspect also. Free copy of the order be handed over to the London Council for the State.
Item 11.
May I please your words?
Yes.
My lord, this is the second bail application, subsequent bail application before your lordship. Once, after hearing, the matter was dismissed, rejected on 23/7/2020.
When it was earlier rejected?
Yes, your lordship. On 23rd/7/2024.
23/7/24
My lord. Para 6, my lord, elaborately discussed about the incident. And para 4, my lord, already the CA was issued by good office. No any adverse.
What is your period of detention?
Lord, I am at about
26/7/2017.
17 years.
So
8 years,
8
3 months.
years. Merit with the reject age.
My lord, once.
Because you on that day you submitted that it was a case of grave and sudden provocation.
And grave also.
But we found that there is no such material. Rather,
My lord.
you came prepared to the spot and assaulted on the vital part of the body like
Head.
head and cause of death is craniocerebral injuries.
My lord. But here, your lordship, I am placing your.
We have mentioned that.
Yes, my lord is already mentioned in the
2,
order.
3, 4, and 6.
My lord. Here, your lordship, all the witnesses who was examined before the landed court below, your lordship, Peter number 1 is the wife.
You see, the merit रे वर्तमान आपण कहिले भी किछि लाभ नाही कारण merit रे already आपनको reject ହେଇଯାଇଛି.
My lord, once rejected.
Among against this order, you have not gone to the higher court, right? So now only after the rejection, 1 year and some months have passed,
My lord.
right? And you are in custody for about 8 years.
My lord.
So 8 years, 3 months ki 4 months हो.
3 months होଛି.
ଏଇଆ ହଉଛି କଥା. Otherwise merit ଆଉ ଯାଆନ୍ତୁନି.
Merit ନାହିଁ ଯେ sir ମୁଁ କହିବା କଥା. There is no motive at all, your lordship, because there is a dispute between the party, between the decision and the
When a
for
case is
payment of
based
the,
on the statements of the eyewitnesses, there is no necessity on behalf of the prosecution also to prove the motive.
My lord.
Right?
My lord.
You have assaulted on a vital part of the body,
This is the
and that is head, and death has taken place on account of such assault.
My lord.
Number of witnesses have deposed against you. So there is no
all the
circumstantial evidence case re motive ro importance ଅଛି. Otherwise a direct evidence रे दरकार नहीं.
My lord. କିନ୍ତୁ all the witness examined are the only relatives of କୌଣସି ବାହାର ଲୋକ examine ହେଇନାହାନ୍ତି. Even the taxi ବାଲା ବି is not examined.
What about अरे ଯେତିକି ହେଇଛନ୍ତି ଆगे ତାଙ୍କ ଇଏ ହେଇନି ସିଏ ହେଇନି.
My lord.
The quality of evidence ଦରକାର, quantity କଣ, quantity ଚାରିଟା witness କହିଲେଣି ଆଉ ଆପଣଙ୍କୁ କଣ ଦରକାର, ସେ ଟ୍ୟାକ୍ସି ବାଲା ହେଇନି, ସେ ଅମକ ହେଇନି, କଣ ପୁରା ସେ ଗାଁ ସାରାଙ୍କୁ ଏକ୍ସାମିନ କରି
ଏତିକି ଲିଷ୍ଟରେ ଥିଲେ.
What you are doing, what was your avocation, and what is your background, family background about the criminal antecedent?
There is no criminal antecedent. Very
Anand ସେଗୁଡା ସବୁ ଆଣନ୍ତୁ ହେଲା. This is an this is an application for bail.
conduct ଆସିଯାଇଛି.
It seems that the bail application of the petitioner was earlier rejected on merit by the order dated 23/7/2024. The Grand Council for the petitioner submits that the petitioner is in judicial custody since 26/7/2017. Let the Land Council for the state obtain instruction about the criminal antecedent, jail conduct, and also the family status and avocation of the petitioner. Put up this matter in the commencing from 1st of December 2025.
8th December. I will be absent 8th December.
8th December 2025.
Item 12.
May please.
So, second round bail application, after rejection, the first round manner,
ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି କେବେ
4/5/2022 months.
4/5/2022. PW4 is an eyewitness to the occurrence and the ground ରେ ଆପଣଙ୍କୁ ରିଜେକ୍ଟ ହେଇଛି କେତେ ବର୍ଷ ରହିଲେଣି ଆପଣ
10 years 7 months.
ମାନେ including remission ହେଇଥିବ remission କୁ ମିଶିକିନି 11 years 6 months ଆଉ କିଛି criminal antecedent
ଜେଲ କଣ୍ଡକ୍ଟ ଭଲ ବୋଲି ଆସିକି ଅନଫର୍ଚୁନେଟଲି ଜଣଙ୍କର ସେ ଦେଇଦେଇଛି ଆଉ 2 ଜଣଙ୍କର ଦେଇନାହାନ୍ତି
ଆଜ୍ଞା କଣ ଏଇଟା 3 ଜଣ କି
ଜଣ
କାହାକୁ ଫାଇଲ କରିଛନ୍ତି ବର୍ତ୍ତମାନ ବେଲ ସମସ୍ତଙ୍କ ପାଇଁ IN number 147 ହଁ ଏଇଟା ସମସ୍ତଙ୍କ ପାଇଁ ଫାଇଲ
ସମସ୍ତଙ୍କ and other ସେଇଟା 2 ଜଣଙ୍କର ଆଉ 2 ଜଣଙ୍କର
the Land and Council for the state custody certificate ସମସ୍ତଙ୍କର ପଳେଇଛି
ନାଇଁ ସେ ଗୋଟେ ଜଣଙ୍କର ଦେଇଛନ୍ତି appellant 1
submitted that he has received the custody certificate only in respect of appellant number 1 Chala Sundi alias Sikar and his jail conduct. However, he is yet to receive the similar instruction in respect of the other 2 appellants and so also the criminal antecedent instruction in respect of all the appellants. And this for an adjournment is this matter will commencing 1st of December 2025. Yes.
Item 13.
May please also. Well, so last occasion, Malaysia call for the criminal antecedent of the present appellant matters.
Ayla. Custody certificate ପଳେଇ ଆସିଥିଲା custody certificate ଦିଆ ଅଛି ଠିକ ଅଛି ଆगे
criminal antecedent last time out
ଏଇଟା ହଉଛି 17/7/2025 ଦେଖଉଛି ଆପଣଙ୍କର 7 ବର୍ଷ 8 ମାସ ତ ଆଉ 4 ମାସ ହେଇଗଲା 8 ବର୍ଷ ହେଇଗଲାଣି ଠିକ ଅଛି ତାପରେ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା
No, Malaysia. That previous IO exposure, as you don't that my lordship directed me to file a fresh IO.
କଣ ହେଲା କୁହନ୍ତୁ
she is not available
ହଁ
criminal antecedent report
jail conduct ବି ଆଣିନାହାନ୍ତି The Land and Council for the state seeks some further time to obtain the criminal antecedent. So also instruction about the jail conduct of the petition. Put up this matter. Yes, next.
Item 14.
Next, please.
Two appellants convicted under section 302 and 301 IPC along with other offenses like 498A, section 4 of DPR. So far the appellant number 1 for whom the bail application has been filed is in custody for 6 years 11 months.
No, you have filed for only appellant number 1.
1 because 2 has been released on bail. Yes, sir. So far as the 1 is concerned, by order dated 19/1/2021, his bail application was rejected and the same time the appellant number 2 was allowed.
19/1/21.
Thereafter, my lord, again by order dated 16/2/2024,
By that order, my lord, it was rejected in view of the earlier order dated 19/1/2020. So far as the appellant number 1 is concerned. My lord, here the conviction is based on the circumstantial evidence.
No. How many years you were in custody?
6 years from the date of conviction, and prior to that he was about 11.
Have you got that instruction? Get it. Custody certificate is an application for bail of appellant number 1. Then counsel for the state seeks some time to produce the custody certificates and jail conduct. Put up this matter on such and such the stay relation of find allowed.
Item 15.
1.
Please, your lordship. The item 15, I am there virtually.
Yes.
My lords, here this is an application for bail of the appellant who is in custody since 2/12/2014, my lords.
Twice the bail the petition has been requested on merit. I will submit the petition has been in custody so and so. Let the land council should state produce the custody certificate, instruction regarding the conduct of this one, health condition of the and criminal anti. ऐसी लगी? Yes.
You are appearing for appellant.
Informative.
Who is appearing for appellant?
I am there virtually, my associate.
First, 11 years, 10.
Custody पड़ेगा.
Custody. Next question. 11 वर्ष 10 मास election.
अच्छा 11 वर्ष 10 मास. अच्छा. बाकी
conduct is next page below.
Nothing adverse was found. IAC. How inside jail? Inside jail, satisfactory, discipline, willingness to work, participation in the vocational program. Baki
health condition is blood sugar 130 mg.
Coronary artery disease. Acha. Type 2 diabetes. Acha. SC medical college treatment house. Loko ko diya raha.
Kotak.
Kotak. Mangala.
Friends colony.
Case kono?
The case of Yuxaricide, my lords. The wife of the deceased was not found on since 24/11/2014. And deceased gave prevaricating statements. The body was recovered, my lords, from the septic tank in the compound of the deceased's house on 1/12/2014. And the appellant's house. And on the next day, the appellant has been arrested and taken to custody.
Case based on circumstantial evidence.
Yes, my lord. Case is based on circumstantial
How
evidence.
many years after the marriage this took place?
My lords, marriage was quite within 7 years, my lords. 498A, 304B, and 406
That is why we are asking
have
you.
been acquitted, as well as Section 4 of the DP Act. All these charges have been acquitted.
Only 302 he has
and
been
201.
302, 201. Because of that safety tank.
Page 182 of the evidence of the IO. I, along with the SI Subhash Jana, of our case left for the house of the accused and at 15 p.m. I arrived there and got some bad smell coming out from the Latin tank of the accused. I also found one dead body inside the tank. Then I examined some other witnesses. I also found Radhakant Pradhan sitting in his safe part shop and on being a fact he told that as a bad smell is coming out from the right side of the Latin tank. We went there and found the dead body of his wife is concealed in the said Latin
Who is the
tank.
doctor?
PW 13 millers.
PW 13.
His opinion is that there is an injury on the neck due to compression of the neck and fatal.
And several other antemortem injuries.
Death is due to asphyxia because of compression of neck.
Lordship, previously it has been rejected twice. But
Yes,
the
yes,
person
I don't
who
dispute.
won 14 and the person who has recovered the body.
It was earlier rejected once before the division bench of my Lord Justice S.K. Mishra and
19-1,
where there was a
24.
divergent view.
Or mention 9.
7/10/2021, 10/8/2022.
Footnote 124.
Yes, my lords. My lords, may I explain that? There was a divergent view for grant of bail. So, again, 7/10/2021. Again. Yes, again.
It was referred to Justice Pujari Millards, who agreed with Justice Rotha's view that bail should not be granted.
29/1/24 as noting in the list.
ହଁ ତାପରେ ଆଉ ଥରେ ଆଜ୍ଞା ଡିଭିଜନ ବେଞ୍ଚ ରିଜେକ୍ଟ କରିଛି ଏଇ ଗ୍ରାଉଣ୍ଡ।
As refused to certificate the petition issues which is dated 5/8/2025. It shows that in full period of redemption, the custody period is 11 years 10 months. And the Grand Council has further produced the written instruction from the IAC, Mandra Police Station, by the FCB, to show that there is no criminal antecedent against the petitions. Similarly, he has produced the report the senior superintendent Circle Jail Katak Chaudhar, which shows that the conduct and behavior of the petitioner towards the jail staff, fellow inmates was found to be satisfactory, and he has discipline, willingness to work, participation in the vocational program, and no serious complaint has been recorded against him during the period. The report further indicates that the petitioner is suffering from coronary artery disease and type 2 diabetes mellitus. The medical documents of SCB Medical College Hospital has also been annexed to the report, which have taken on record. Mr. Devasis Panda, Land Counsel for the petitioner, submits that when the bail matter was first taken off, of the petitioner was first taken off on 7/10/2021, there was a divergent view of the division bench, for which the matter was placed before the learned third judge, and the honorable third judge rejected the bail application by the order dated 10/8/2022. The Subsequently, the bail application of the petitioner was also rejected by order dated 29/1/2024. He submits that case is based on circumstantial evidence, and since there is no chance of early hearing of the appeal in the near future, taking into account the period of detention in judicial custody, the bail application may be favorably considered. Land counsel for the state as well as land counsel for the informant oppose the prayer for bail. Considering the submission made by the land counsel for the respective parties, and in view of the available materials on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention, judicial custody, absence of any criminal antecedent, his health condition, as well as his conduct inside jail, we are inclined to release him on interim bail for a period of 3 months. While on interim bail, he shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yes, next.
Grateful. Lordship, if I may, the paper book is ready. It can be there for final clearance.
You want a paper book copy?
No, I have this.
Okay. Yes, next.
Item 15.
Item number 16.
Item 16.
One next week. The Land Council for the appellant 6 for an item. Release this matter next week. Yes.
Item 17.
May I please, Your Lordship? My Lord, last occasion, order number 6, IN number 1820/2025, police report मंगाया था।
What was his conduct during the interim bail period? You are released, Mr. Tripathi, on interim bail by the order dated 21/25 for a period of 3 months.
Yes, madam.
And by that time, it is mentioned that you are 65 years and in custody for more than 9 years, 10 months. Achha. Okay.
Madam, every 10 years, sir.
No adverse report. Are the Land and Council, Mr. Tripathi, Land Council appearing through virtual mode, and Land Council for the state. The petitioner was granted interim bail for a period of 3 months by the order dated 21/2025. Taking into account his age, his period of detention in judicial custody. After availing the interim bail period, he has surrendered at right time. As per our previous order, Land Council for the state has produced the written instruction received from IIC Thakurgarh police station, which shows that the conduct of the appellant, that there was no adverse against the conduct of the adverse report against the conduct of the appellant while on interim bail. The report is taken on record. Considering the submission made by the Land Council for the respective parties, period of detention in judicial custody, age of the petitioner, and since the petitioner has not flouted the terms and conditions of the interim bail order, and absence of any chance of early hearing, and keeping in view the ratio laid down in the case of Reddy versus Swansea, we are inclined to release the petitioner on bail. Allowed. Yes.
Item 18.
Three appeals are there. The appeal number 1 for Virendra Majumdar, I am moving an application for bail. My lord, here 3 appeals have been listed, my lord.
Yes.
First appeal for Virendra Majumdar.
You have, okay, first Virendra Maji, right?
Yes. Here, my lord, he has been convicted under section 366, 376D and section 6 of the Poxo Act, my lord. And sentenced to undergo arrest for life. He's in
Poxo
custody.
Poxo. Poxo is there. Notice.
Notice.
Aro 2025 with the tomato situation. Next.
Item 19.
Yes, Mr. Rautray.
May I please, sir? After availing the interim bail by a surrender for court below, it is on my lord, dated 12/24.
Have you surrendered?
Yes, sir. I've annexed the certificate of this case.
How many times you have gone on this?
First time, only the last occasion. 3 months.
But as we find, there are two interim applications. One is order dated 12/24. जीटा वीडियो तो सेम order रिसीव है अच्छा ठीक है दिथर कहीं से उठा ये कोट ये देखो 12/8/2024 तापर पुणी ये कर पुणी अच्छी से 12/8/2024 रो बुझी पड़ जाना तो दिथर वही गाड़ी तो बोलते है ना कंफ्यूजन so you have filed a fresh bail
Yes, yes, sir.
oh have you taken instruction about the conduct of the
No, we are not
check
On police.
police.
IN number 2848 of 2025. This is an application for bail. Mr. Rautray and Council submits that after availing the interim bail period, as per order dated 12/8/2024, passed in IN number 921 of 2023, the petitioner has surrendered at right time.
Yes, sir.
Stop. The Land Council for the state took some time to obtain instruction regarding the conduct of the petitioner to the concerned IAC, put up this matter on AK-12/2025. Yes, next.
Item 20.
Yes, Mr. Parida.
Mr. Das was appearing in lordship last occasion directed just took time to file
Abhishek Das.
comprehensive affidavit time to come.
Yes, he has come. Yes, Mr. Das. Have you filed your comprehensive affidavit?
Yes, madam.
Give a copy to the State Council for verification. And file it.
Copy was served, madam.
You know.
Have you verified from office? If extra copy is there.
That comprehensive affidavit is available in the court.
What is the use of giving advance copy then?
Okay,
To collect it.
give a file collect it. ये नहीं त्याग ही नहीं.
Okay. So this is 10th of
November. Was asked by the council appearing for the appellant submit that as per the previous order, he has filed the comprehensive affidavit regarding the status of the criminal cases instituted against the petitioner. Let the office place the same on record. Though it is stated by Mr. Das that the copy of the comprehensive affidavit has also been served in the AG office, but the Land Council for the state submit that the same has not been tagged to the file and the matter may be taken off on some other day.
You are appearing
so
for?
that informal. So, and you have received the copy?
Yes, sir.
Okay. Copy of the comprehensive affidavit has also been served on Mr. Satpathy, Land Council for the informant. Put up this matter on 1st December 2025, the Land Council for the state shall obtain instruction on the comprehensive affidavit filed. है ना? 1/12/2025. Yes, next.
Item 21.
Character certificate as has Mr. Raut की engage करली तांकर सब detail नहीं
Last occasion, directed to
That I am providing that conduct.
extension of the interim bail.
No, my lord. On the order
not
dated,
received.
my lord.
अब
Order
बाकी
19 order dated 19/9.
तो अपन ଯାଇଥିଲେ କି interim bail
My lord. 3 to 4
କେତେ ମାସ?
3 to 4 days I have to release interim bail, my lord.
20 days you have now.
Last week.
आप पूरा हो ଯାଇଥିଲେ?
My lord.
3 occasion.
ओहो
For this
केबे केबे
release,
केबे कोहुनांती अरे बेल केथर ଯାଇଛन फास्ट केबे ଯାଇछन
25
my lord, order dated 7/7/2020.
जस्ट
Right.
साथे
7/7/2025 it was reflected, my lord.
ओ केते थर बेल ଯାଇछन आपण रिजेक्ट
3 थर जाइए, my lord, on dated 25/4/2024,
25/4/2024
my lord.
के
1
दिन
month
पे
24 days.
24 days
1 month 24 days. Also, it custody certificate also there.
हमको केते थर बेल ଯାଇछन 16/11/2024 रे रिजेक्ट हला
25/11/24
25/4/2024 रे we are inclined to direct अच्छा तो फास्ट बेल ଯାଇछन 25/4/2024 for some period then
29/8/24
29/8/2024
28/2/25
just a minute it all 4 weeks तापर आउट हला
28/2/25
हां 28/2/2025 रो लास्ट टाइम जो ଯାଇଥିଲେ ସେଟା 4 weeks ପାଇଁ
4 weeks.
अच्छा ସେଇଥି ପାଇଁ ଆପଣଙ୍କୁ କୁହାଇଥିଲା ତାର conduct ର ଆଣିବା କଣ ହେଲା ଏଇ
conduct is
conduct is good but the health issue of the father is serious and bedridden instead କାହା ବାପା ମାନେ यार ବାପା
District. The present applicant.
ତ ଯୋଉଥି ପାଇଁ ଆପଣ interim bail ଯାଇଥାଏ ସେଇଥିପାଇଁ ଫାଇଲ କରିଛନ୍ତି ପିଟିସନ
No, no.
ଆଉ
IN number 1218
ବର୍ତ୍ତମାନ ଯୋଉ ଆଇଏଟା ଫାଇଲ କରିଛନ୍ତି କଣ ବାପାଙ୍କ ଇଏ ପାଇଁ ନା କଣ
regular.
ଭାଇ ଏଗୁଡାକ ଅଛି ପୁରା ଆହୁରି ଗୋଟେ ଆଇଏନ ନମ୍ବର ଦେଖନ୍ତୁ 1317 of 25 ଗୋଟେ interim bail ଅଛି
Dispose of, madam.
dispose of କେବେ dispose of ହେଲା
7/7
1317
pending
ନା ନା dispose of ହେଇନି dispose of ହେଇଥିଲା ଆସିନଥିଲା ଏ ସବୁ dealing assistant ମାନେ ଦେଖୁଛନ୍ତି ତ ସେ no it is so you don't want to press this interim application
Yes, ma'am. That was also dispose of order dated 19/9/2020.
huh
19/9 that was also
99
2025. It was
19/9/25 ରେ ଆମେ ଗୋଟେ ଆଇଏ କୁ କନସିଡର କରିଛୁ ସେଟା ହଉଛି 2347 of 25 not this one 1317 ନୁହେଁ ଦେଖନ୍ତୁ IN number 1317 of 25 this is an application for interim bail London Council for the appellant does not want to press this application ହେଲା disposed of as not pressed 1317 ଟା ଗଲା not pressed ତାପରେ ଆସୁଛି ଆହୁରି କେତେଟା ଫାଇଲ କରିଛନ୍ତି
ये गोटे appellant আছে
ଗୋଟେ applicant
କେଇଟା ପୁଣି ଆଉ ଗୋଟେ ଅଛି 27/4/2023 ତାପରେ 2442/2024 1318/2025 ହଁ ଗୋଟେ interim application ତିନିଟା ନଉଛି for ମାନେ merit ରେ ତ ଲାଟେଷ୍ଟ ଟାକୁ ନଉଛି ଆଉ ଦିଟାକୁ ନଟ୍ ପ୍ରେସ୍ କରିଦଉ ଦେଖନ୍ତୁ IN number 2704/23 not press ତାପରେ 2442 of 24 not press ସିଙ୍ଗଲ appellant ତ ବର୍ତ୍ତମାନ ଏଇଗୁଡାକ କୁହନ୍ତୁ ଯାହା କହିବା କଥା 1318/2025 ଆପଣଙ୍କର କଷ୍ଟଡି ପିରିୟଡ କେତେ କୁହନ୍ତୁ?
on bail. The custody certificate also I have given.
Total sentence including remission 2 ବର୍ଷ 5 ମାସ 1 ଦିନ
ଜମାରୁ
He was on bail. Only circumstantial evidence.
merit ରେ reject ହେଇଛି ପରା
But for this reason it was called for on dated 7/7/2025.
ଆପଣଙ୍କର ବେଲ ମେରିଟ ରେ ରିଜେକ୍ଟ ହେଇଯାଇଛି ବର୍ତ୍ତମାନ କଷ୍ଟଡି ଗୋଟେ ଏମିତି ପିରିୟଡ ହେଇନି ଯେ ଆପଣଙ୍କୁ ବେଲ ଦିଆଯିବ 2 ବର୍ଷ ଜମା ରହିଛନ୍ତି ଆଉ ବାପାଙ୍କ ଗ୍ରାଉଣ୍ଡ ରେ ଆପଣ ଯାଇଥିଲେ
Prior to that 7/7/2025 I have directed I have withdrawn all the bail application thereafter. My lord, after that the bail application of the petitioner was rejected on merit dated or dated 16/6/26. However, granted interim bail for some time in different interim bail application. Leave the matter will commencing of Mishra and Royal Council for the state obtain the instruction regarding the conduct of the execution while on bail.
ଆଉ ଠିକ ଅଛି ଆମ ନୋଟିସ କୁ ଆସିନି ଯେ ଆପଣ ଜମା 2 ବର୍ଷ ରହିଛନ୍ତି ଆମେ ଜଷ୍ଟ ଭାବୁଛୁ ଯେ ବୋଧେ ଗୁଡାଏ ବର୍ଷ ରହିଗଲାଣି ତ 2 ବର୍ଷର କଣ ତା ଭିତରେ 2 ବର୍ଷ ରହି ଆପଣ 3 ଥର ଯାଇକି ବୁଲିକି ପଳେଇ ଆଇଲେଣି ନା of course on the father's ailment ground you have gone and your father's health condition is not that also good but you have not pressed that interim application
Though father was died and I also released on interim bail.
died
Last occasion
acha
for that reason
তাহলে এটা রইথাও এটা କରିଦିଅନ୍ତୁ January 2025 2026 yes next
died on which date? So read the date. Interim bail, my lord. Tell the date. My father died when? Date of death. Six 8/2025. Minor.
Item 22.
To my lord, I done IA for interim bail. The ground of doctor's marriage.
that is the last time it was submitted we have sent it for instruction within some more time because
22. Next month. 2. Back.
नहीं only गला 10 तारीख देते 14 जाइए पेपर 2 days time
एक पूरा
On advancedly I mentioned and soft copies to
14 तारीख कॉपी सर को मैं से संग दे ये 14 कॉपी देना दे 15 16 नहीं नहीं दिस वीक
Item 23.
In item 23, I appear for the appellant number 1. My learned friend Mr. Pradhan appears for the co-appellants, my lords. On the last occasion, it was stated by the prosecution that there is one antecedent of the appellant number 1. Now, I have filed that judgment acquitting me, my lords.
State level of answer. Nothing I. 394 case additional session trial is
The certified copy, my lord, is available with me.
No, it is 50 kengola. With you 394 case additional session Panjanagar sessions trial is a trial is the magistrate trial of ST case. Yes, Mr. So now, what is the offense here? You have been
Offense here, my lords, is 302 read with 34 IPC. It's a case of triple murder said to have happened on 11/7/1996.
11/7?
1996. Judgment was pronounced on 20th of October 2023, my lords.
So what 2023? Yes.
My lords. And I was taken into custody thereafter because during the trial, I was on bail from 7/11/1998. So for more than nearly 25 years, a quarter century, I have been on bail as an UTP.
Okay. What are the materials against you?
My lords, the prosecution led evidence of 3 witnesses who were said to be eyewitnesses.
Yes.
Out of these 3 witnesses, PW20 Babuli alias Bharat Naik was not a charge sheet witness. He was examined under 311 by the prosecution, and in his initial examination, he supported the prosecution case. But when he was recalled on 4/12/1998, he did not support the prosecution story. The prosecutor also did not declare him hostile, my lords. And he had identified the accused persons. To a query to the court, he stated that on the previous date of his examination, he had seen these accused with handcuffs in the court veranda, and he guessed from the gossips that they were the accused, and therefore he had identified. The next witness, eyewitness whom the prosecution relied upon is...
Yeah, just a minute, Mr. Panda. So far as PW20 is concerned,
my lords,
we find that in the examination in chief,
my lord,
he has stated everything. That
yes,
including the identifying occurrence took place.
Yes, my lords. With regard to that identification, your lordship may see his evidence on recall. When he was recalled on 4/12/1998.
I was not examined by the place of occurrence. I did not know the injured persons who were lying on the. I know, nor I know who were greeting. I was witnessing the occurrence so and so. I could not recognize the persons who took part in the occurrence. On the last occasion when I came to so and so, I found the accused sitting on the court veranda. I had the occasion to see the accused for 15 minutes. To quote, the people were gossiping in the veranda relating to the persons who are sitting with hands off. I guess that he is accused present. Prior to this, no PO parade was held. I found so. And
the next witness is PW21, my lords.
yes.
PW21's evidence was expunged because he did not turn up for cross-examination. So therefore, we are left only with the third witness, PW6, my lords, Kamal Sri Mahanti. The Kamal Sri Mahanti, my lords.
Where is that Mr. Panda jo cross examination ko asilani beli seta kothi?
সেটা জাজমেন্ট লেখা ହେଇଛି তারপরে
paragraph expunge ହେବା ଜିନିଷଟା କୋଉଠି ଉଲ୍ଲେଖ ହେଇଛି କୋଉ paragraph?
ତା ଅର୍ଡର ସିଟ୍ ଟା ବି ଅଛି ଆଜ୍ଞା
26/3/19 ଅର୍ଡରରେ ସେ ଏକ୍ସପଞ୍ଜ ହେଇଛି ତା ଏଭିଡେନ୍ସ 26/3/99
1999.
Okay. Then what about the third one?
That is PW6, Kamal Sri Mahanti. He was examined as an eyewitness, my lords, on 16/12/1996. And he supported the prosecution story at that time. Thereafter, my lords, one of the appellants had not cross-examined him at the trial. So on recall, he was examined on 9/1/2023, my lords. And when on recall, he did not support the prosecution case. And the PP declared him hostile. And he denied to have been examined during investigation and to have witnessed the incident.
Okay, what about the other evidence? Suppose let us say this is so far as the three eyewitnesses are concerned.
My lords, there is no other evidence, my lords, incriminating them. And your lordship also, during the appellate stage, has granted the appellant number 1 interim bail thrice, my lords.
ଏଇ appeal ରେ ଯାଇଥିଲା
ଆଜ୍ଞା ଅର୍ଡର ଡେଟେଡ୍ 16/5/24 21/8/24 13/11/24 my lords.
21/8/24
ତାପରେ 13/11/24
but merit reject ହେଇଛି
ଆଜ୍ଞା
ଆଉ ଗୋଟେ ହଉଛି
13/11/24
His age about 78 years.
No.
He is 55. As a mother of the appellant is 78 years.
Milords, throughout the period of bail, Milords, there has been no allegation against. This for more than nearly a quarter of a century.
Same thing happened to you also.
Yes. But twice we have been granted interim.
No, that is there. The question is that merit bail rejected to say thing. What do you say about it?
Just I received the complaint affidavit. Complaint affidavit just now I received.
ସେଟା ତ ଆକ୍ଚୁଆଲି ଗୋଟେ ସେ କେସରେ ସେଟା କେବଳ ଆପ୍ରାଇଡ୍ ନମ୍ବର 1 ନାଁରେ ଥିଲା। ତ ଏଥର ସେମାନଙ୍କୁ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦିଆଯାଇଛି। So any adverse report against
those reports were there before your lordship. On the last occasion, those reports are already there with your lordship.
Right.
Along with it.
Plan
G.
ତାଦେହରେ କିଛି ଲେଖା ହେଇନି, କେବଳ ଲେଖା ହେଇଛି ଯୋଉ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ବିଷୟରେ ଲେଖା ହେଇଛି। However, as it accused to could not be in obedience to the letters of the I am honored to submit that verified the CA of this one so locality could not found
more time to that is the reported at 27/10/25.
27/10 ରେ ଲେଖା ହେଇଛି ତାଙ୍କର ଯୋଉ କେସ୍ ଗୁଡାକ ସବୁ ଯୋଉ ଅଛି। There is nothing in this about the conduct during it.
Rather, the conduct of the deceased Milords is that they had criminal antecedents and were
not. So you obtain it like who ଥାନାରେ ଅଛି?
ଏଟା ଆସିବ ଖଣ୍ଡଗିରି
କେସ୍।
ଆଚ୍ଛା ଦେଖନ୍ତୁ, it seems from the order sheet that the appellants ନାଁ ଲେଖିଦେବେ ଦି ଜଣଙ୍କର।
3 ଜଣ।
3 ଜଣ?
ଆଜ୍ଞା।
3 ଜଣ ପାଇଁ ବେଲ୍ ଫାଇଲ୍ ହେଇଛି? ଆଚ୍ଛା।
ଆପଣ 2 ଜଣ ପାଇଁ ଫାଇଲ୍ କରିଛନ୍ତି?
ହଁ, ମୁଁ 2 ଜଣ ପାଇଁ।
ଆଚ୍ଛା, the appellants ଜିତୁ alias ବିଶ୍ୱଜିତ ଦାସ, ଛୋଟୁ alias ଚିତ୍ତରଞ୍ଜନ ପାଢୀ and ରୁଦ୍ର ନାରାୟଣ ସାହୁ। ଏମାନେ 3 ଜଣ ଯାକ ବେଲ୍ ରେ ଯାଇଥିଲେ ତ ଇଣ୍ଟରିମ୍ ବେଲ୍?
ଆଜ୍ଞା।
were granted bail price by this court.
ନା ସେ 2 ଜଣ ଆଜ୍ଞା ଦିଥର appellant 1 twice ଏ 2 ଜଣ ଦିଥର।
Acha. The appellant number 1 has been directed to be released on bail thrice. That is by order dated 16/5/24,
21/8/24,
21/8/24,
and 13/11/24.
So far as appellants Choktu alias Chittaranjan Padhi and Rudra Narayan Sahu are concerned.
16/5/24 ରେ ଯାଇଛନ୍ତି, 21/8/24।
They have been granted bail twice, that is on 16/5/24 and 21/8/2024.
Appellant 1 has also been granted parole Milords for some time.
The appellant number 1 is stated to have been granted parole also. The London Council for the State shall obtain the instruction regarding the conduct of the appellants while on interim bail. ତା ପୂର୍ବରୁ ଲେଖି ଦିଅନ୍ତୁ, in the London Council for the appellant as per the previous order dated 27/10/2025 has produced has filed a comprehensive affidavit relating to the case which was instituted against the appellant number 1, which are annexing the judgment passed in the said case, which shows that the appellant number 1 has been acquitted. The affidavit copy is taken on record. If affidavit copy, the affidavit along with the judgment is taken on record. Copy of the same has been served on the land and council for the state. Instruction next figures. Yes.
Item 24.
Yes.
Order dated 43/9/25 for custody certificate.
Extension of the interim bail, not pay such a custody certificate, criminal antecedent, conduct inside jail. हजार 768 दिन केते होची
वर्ष 5 मास
आउ कंडक्ट सर्टिफिकेट तो कौन है अच्छा कंडक्ट इनसाइड जेल फेयर एंड सैटिस्फैक्टरी अच्छा क्रिमिनल एंटीसीडेंट ना आगुर बेल रिजेक्ट ही कि मैडम
26/6/24
24/6/24 हाँ अपन को रिजेक्ट ही ची काई नहीं करले
and 12/11/24
12/11/24 नहीं नहीं 12/11/24 की छोड़ो ना
12/12/24 उड्रो
अच्छा एटा 3 months हो जाई
24 महिना
18/12/24 रे 3 मास बेल दिया इतला फास्ट 24 रे रिजेक्ट इतला
12/12/24 रे उड्रो
not available. कितना नाम देखो दिलीप अजय अजीत राकेश
Lord, eyewitness Minnie Khara declare hostile malice.
gunshot injury gunshot injury
कोई ना आई विटनेस हॉस्टाइल ही ये आई विटनेस की
My Lord, Minnie Khara.
नहीं गुट्टी आई विटनेस
My Lord. PW8, my Lord.
But circumstantial evidence is there.
Schedule 7, the confessor.
You were on that roof and gunshot was fired, and when they went, you were found coming down the roof to the ground floor holding that pistol, and because on the roof the murder took place, so they went, that is PW1's version. So on reaching the roof of the house, we noticed my deceased sister Pinky had sustained bullet injuries on the head. So by parking the vehicle, you had gone upstairs, that is on the rooftop, and then gunshot injury they had, and when they rushed to the roof, you were coming out of from the steps holding a pistol, and on the roof the dead body of the deceased was found with bullet injuries. So that is there.
Schedule 7 is also self-compensatory.
Immediate ହେଇଛି ଆପଣଙ୍କର ଏ ଯୋଉ ଜେଲ ଯାଇଥିଲେ 18/12/2024 ତାଙ୍କର ସ୍ପେସିଫିକ ଇନଷ୍ଟ୍ରକ୍ସନ ଆପଣ ଆଣିଲେନି, ସେତିକି ବେଳେ ତାଙ୍କର କଣ୍ଡକ୍ଟ କଣ ଥିଲା? ଆପଣ ଯୋଉ ଆଣିଛନ୍ତି କଣ୍ଡକ୍ଟ ଇନସାଇଡ ଜେଲ ଆଣିଛନ୍ତି, ଆମେ ଆପଣଙ୍କୁ ଯୋଉ ଜିନିଷଟା ସବୁଥିରେ ମାଗୁଛୁ ଯେ his conduct during the interim bail period, ତେଣୁ ସେଇଟା ଆଣିନାହାନ୍ତି। IA number 1079 of 2025. This is an application for bail. It appears that the petitioner was granted interim bail. I had order dated 18/12/2024. For a period of 3 months. The Learned Counsel for the state has produced the custody certificate of the petitioner to also his jail conduct. However, he seeks for an obtain instruction regarding the conduct of the petitioner while on interim bail. Put of this matter on 1st of December 2025. These are taken on the What is your good name?
Ira Das, madam.
Rest of the matter day after tomorrow.